1, 2, 3. Check. 1, 2, 3. Yeah. Good morning, everybody. Thank you for your patience. We had some technical difficulties this morning, but we are ready to get started. In accordance with Section 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. The Committee of Adjustment considers applications for variances from the provisions of the zoning that applies to property, permissions to extend or alter lawful non-conforming uses, and consent to sever property to create new lots. We acknowledge the land we're meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis people. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid in-person and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx, an online digital platform. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computer, tablet, smartphone, or telephone and have the option of participating via video or audio only. All virtual participants will automatically be muted on entry. When your item is called, you will be unmuted by the moderator, one person at a time. We also ask that you mute your devices until you are called on to speak. Those participating by video appearance will be temporarily upgraded to panelist when your item is being held. During this time, your camera will be enabled. You will only be visible during your 5-minute allotted speaking time. At all other times, your video will be disabled and you will be reinstated as an attendee. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. Those participating through WebEx are not allowed to use share screen or any other panelist controls during a video appearance. The host will remove you from the panelist role if you fail to respect that instruction. People attending in person and people attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for decision by email. Please ensure that you include your name, address, and email address because the Committee of Adjustment and the Toronto Local Appeal Body will be sending notifications and appeal updates by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons, and public bodies, as those terms are defined in the Planning Act, are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. In terms of the procedure today, I will call each item in the order listed on the agenda. We will start with dealing with our deferral request first, and then we will move in order, as I stated. When an application is uncontested, the agent or applicant may proceed with their presentation if desired. When the committee does not require a presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and or take the matter into committee for a decision. Each speaker, including the applicant or agent, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching your 5 minutes. Any presentation or other materials you wish to submit to the committee must have been emailed in advance of the hearing. Staff and committee members cannot accept material at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and make a presentation to the committee on the application. Please note that the committee may not entertain revisions to proposals at the hearing. The committee may decide to defer the application if substantially revised to ensure the revised application is accurate and that all those entitled to notice of the application are informed of the changes. Then, individuals either in support or opposed to the application will be invited to speak. Generally, we call on speakers in the hearing room first and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation, and when all speakers are finished, the applicant or agent will have an opportunity to rebut only those comments or issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. Okay, before we get to the first item, I just have a few comments from our Deputy
Sorry, Mr. Chair,
Secretary Treasurer.
can we just do the minutes too, to adopt?
Yes, thank you, of course. All right.
I can read them out.
Yeah, of course. Let's go through our minutes.
Okay. Our first set of minutes is October 24th, and the members present were Ms. Casson, Mr. Marzari, Ms. Martin, Ms. Sankar, and Mr. Nipfeld.
Okay, do I have a motion? Yes, Ms. Martin. A motion.
I propose a motion to approve the minutes of November 24th.
October 24th.
October 24th.
Oh, I'm sorry, was it November or?
Well, we'll get to November a bit later, but this first one is for
October 24th.
Okay, do I have a seconder? Okay, second by Mr. Bartolo. All in favor? Okay, unanimous. Motion carries.
Thank you. Members, our second set of minutes is November 7th, and present was Mr. Allison, Mr. Kubo, Mr. Bartolo, and Mr. Nipfel.
Okay, can I have a motion? Mr. Nipfel?
I'd like to move approval of the minutes.
All right, can I have a seconder? Mr. Bartolo, thank you. All in favor? It's unanimous. Motion carries.
Sorry, and our last one isn't November 24th. It's actually November 21st, and that's our last set of minutes to approve today, and present was Ms. Casson, Mr. Jordan, Mr. Fazeli, Ms. Sankar, and Ms. Martin.
Okay, can I get a motion? Yeah, Mr. Bartolo.
Sure. I'll put forward a motion to adopt the minutes.
All right, second by Ms. Martin. All in favor? That is unanimous. Motion carries. All right, are there any declarations of interest of panel or staff for any of the items in our morning time slot? No conflicts there. All right. Do we have any deferral requests that have been received?
We do. Before we get to the deferral, can I just say a couple of quick words?
Yes, of course.
Thank you very much. So I want to say a few words to our applicants and to the public to thank them for the patience as we had to cancel our December 5th hearing due to the Canada Post strike. And I wanted to mention that we are making up for the pause with this hearing today. And in order to move forward after the Canada Post labor disruption ended, for this hearing and for our next hearing on January 23rd, the Committee of Judgment has utilized alternative forms of providing hearing notice. This was done in compliance with the requirements of the Planning Act, which was amended, granting municipalities the ability to use alternative methods of providing notice. Many will have seen the same information on our Committee of Adjustment website, which outlined how we have utilized these alternative methods of providing notice throughout the month of January, including providing updated hearing information on our city's website, providing links to our upcoming hearings and agendas, through ads taken out in the Toronto Star, through the city's social media channels, and through notice signs posted on the subject properties. And with that, I wanted to wish everyone a Happy New Year. This is the first hearing of 2025, and I will let Mr. Chair continue on with our hearing.
Thank you, Mr. Deputy Secretary Treasurer. I should ask before we move on, are there any files to close?
There are no files to close.
Okay, thank you. Okay, let's start with our first deferral request, our first and only deferral request this morning, which is item number 6, 177 Sheppard Avenue West. So the purpose of this application is to convert the existing commercial building into a detached dwelling. We've got variances, actually one variance, to permit the detached dwelling with a second suite in this zone. And on file, I've got material from the applicant. Have our applicant or agent with us?
Yes, good morning, Mr. Chair, panelists, and attendees.
Good morning. It is my understanding that you are requesting a deferral?
Yes, we would like to defer this project because we got the staff report uploaded on January 14th, and we need more time to talk to the community planning department regarding this application.
Okay, very good. I see that we do have...
Mr. Chair, we just need her name and address.
Yes, thank you. Let's get your name and address before I'll let you go
Yes.
for a minute.
Yes. My name is Tatiana Quintana. I'm from TBM Engineers, Inc., and the application is regarding 177 Sheppard Avenue West,
And your address?
15 J. Lynn Court,
Oh.
Woodbridge, Ontario, L4H106.
Okay, thank you very much. Okay, I do see that we do have another speaker. We have a Mr. Goldfinger online.
We've unmuted the speaker.
Hello? Mr.
Hello, can you hear?
Hi. Mr. Goldfinger, your name and address for us?
To the speaker, can you please not unmute yourself? We will do it from our end.
Hello?
Hi, can you hear me?
We can hear you now, yes.
So again, my name's Brian Goldfinger, like the James Bond movies, my last name. Address 167 Sheppard Avenue West, North York, Ontario. Postal code Mary 2 Nancy 1 Mary 9.
Okay, thank you. And you've heard that the applicant is requesting deferral at this time. If you have any comment that speaks specifically to the deferral, now would be your opportunity.
Yeah, I just feel like we were served by, I'm the owner of the property 177. I just think that we were served by the city under 48 hours before this hearing. And it feels like a litigation by ambush because we've had no chance to respond or to chat with the city further about, their objections to our plan. And there's a lot of controversial or contentious statements in their report.
Mr. Chair, can I just verify if he's the owner of the subject property?
Yes.
I am, yes.
Okay, very good. So you obviously have no issue with the request for deferral by your agent.
Correct.
Fair enough. Okay, thanks. Let's go back to the agent. Ms. Quintana, I don't suspect you have any comment, given that your client that made the last comment. So if it's all right with you, I'll look to my members and see if we can have a motion for a deferral for you. Okay, let's take this into committee. Yes, Mr. Nitfeld.
Thank you, Mr. Chairman. I'd like to move deferral of the application to allow the applicant to consult further with the city.
Okay, do I have a second? Second by Ms. Martin, all in favor? Okay, that is unanimous. The deferral request is approved.
Thank you,
Thank
Mr.
you.
Chair. I don't have any other deferrals for the morning.
Okay, very good. All right, starting with item number 1, 241 Horsham Avenue. This is an application for consent as well. We've got some minor variances related to side yard setback for rear platforms and canopies, lot area, lot frontage, front yard landscaping, front and rear main wall heights, and east and west side yard setbacks. On file, we have material from the applicant, an email from Heritage Planning, a memo from Engineering and Construction Services, a memo from Development Planning and Review, letter from the TRCA, as well as an email and a separate memo from Urban Forestry, and one letter of concern from 245 Horsham Avenue. We have the agent with us.
Yes. Hi,
Good
want me to
morning.
make a presentation?
Yes, but before you do
Morning.
that, let's get your name and address.
My name is Chuan Liang. I'm the architect. My address is 106 Thomas Foster Street, Markham,
Okay,
L6C2W6.
okay, thank you very much. All right, you are the only speaker on this item. There are some comments that we received from staff. I would like to see a presentation, so let's get the 5 minutes up for you, and the floor is yours.
Okay, in our submission, we propose to demolish the existing dwelling and garage and sever the land to 2 lots and build each lot with a 2-story duplex dwelling. So the concern of the staff, I read the staff report. So the planner has no issue with the lot severance. That's good to know. And the concern is about the east side yard setback, which is we propose 0.91 meters, and the request is 1.8 meters. The reason we're doing is we want to we only request the garage portion, not the whole east side wall. Only the garage portion we request the 0.9 meters so that we can have a 2-car parking, which is 5.37 meters instead of 1.5 parking. And we have an example. It's 338 HORSHAM Avenue. So this property is the same situation as lot severance, and also they have 0.9 meter setback at one side of the garage. So we would just the owner would like to have the same variance for their own lot. There's another concern from this planner about the main wall height. The reason we request the main wall height is the main wall character is a kind of modern design style. So if the staff can open the front elevation, then the committee can see what the style look like. And it's only for the main front wall. And the side and the rear wall, we all have the 7.5 meter eve height. And I think that follows it has been follows the character of the neighborhood. It's inconsistent. It is consistent with the neighborhood style. And the rear wall is because the width of the building and the window portion, I think is more than 40% of the whole width. That's why it has a height variance. Otherwise, we have the 7.5 eve height all the way from side to the rear. And for the forest concern, the owner and the neighbor also has a concern of the removal of their own backyard tree, and the owner is fully understand and respect the bylaw and the owner's wish. And in the forward step, we will cooperate with urban forestry staff and the neighbor to obtain the required permit and in the conditions of the urban forestry. I think that's all for my presentation. Thank you.
Okay, thank you very much. I believe we will have some questions for you. I do notice that urban forestry has some concerns with the consent as it may facilitate the removal of a city tree. And I hadn't heard any submissions from you with respect to that matter.
I think that will be conducted for the permit application, tree permit application in the next step, right? And also on the same street, we have we noticed there are many severance already there, and the trees has been replanted, and it has been built, grown up. So,
Okay, but fair forestry is
and
not
the
simply,
owner,
it's not a matter of asking for an application. It's not an administrative issue that they've raised. They've raised an issue with the removal of the tree. I should ask, have you been in any discussion with urban forestry, and is there any way to work with them to maintain this tree by shifting the driveway?
it's no, yeah, the forestry already in their report, they already said that it's no way to keep the tree. It's
I'm
too
asking you,
narrow.
though.
It's no.
So let me
Yeah,
ask
it's
you,
too narrow for the car.
what is the distance between the tree and the property line?
Let me remember. It's where is this? It's from the center of the tree to the,
Fair enough. It gives us an approximation.
it's the 6.5 meters.
6.5 meters, and
From
in,
the center of the tree to the side, 6.5 meters.
fair enough. And you wouldn't be able to get a driveway on the side there without
No.
maintaining that tree.
Mhm.
6.5 meters.
Yeah, and you know, the owner is sibling, so brother and sister, so they would like to build their own house. So each person build a new house for themselves. So
Okay.
that's why they want to sever the lot.
Oh, I don't have it. I'm asking you about the tree and whether or not you could we could facilitate a
Yeah.
consent and still maintain that tree in the front. You've noted you had 6.5 meters between the tree and the property line, but I think we have some more questions that might help to give us a little bit more, a better understanding of the application here. Mr. Netful?
Thank you, Mr. Chairman. I have two questions. One has to do with the driveway. The garage appears to be an oversized garage. Is it a double-car garage, and is the driveway therefore a larger than normal driveway? That's my first question. My second question, which is a larger one, I actually do have trouble with the consent. I don't see any information here about the lot analysis in the area, and I would like you to provide us with a lot analysis of where in close proximity we would find lots of the size that you're proposing, because I have concern that, as far as I can see, they're out of character with the existing street. So can you convince me that I'm wrong?
So if you see the zoning bylaw map, you can see many lots are under 50 meters and almost 10 meters, or not even 10 meters, or 11 meters, many of them.
Do you have a drawing to illustrate that? There's nothing in the agenda that indicates anything about
yeah,
the
but
size of other lots.
I have in my computer, but when I saw the staff report, I thought maybe I don't need to send that, because the planner also said in their report it's already established. So
That's
cannot
fair
share
enough,
my screen, right?
but it is your role is to convince us that this is appropriate, and I have serious questions about whether the consent
so
is consistent with the area, which is the reason for my question.
Perhaps to put you on the spot, perhaps you have some addresses or numbers that you could let us know.
yeah, I have that. So there 208-210 Horseman Avenue. That's that's and 232 Horseman Avenue, and 170, 172, 174. So these properties all been severed. I think maybe a long time ago. It's
Do you-
not new.
for
So
two-
some are new. Some is.
Very well. Do you know
And
with 230
the
and
one-
232 what the frontage is there, or the?
It's like 10 meters. And also 338 or 338 Horsham Avenue, and oh, there's another property. It's 1 210. 210. It has
They're not in this,
8.5.
are any of those properties in the same block? If you look at the location map,
Just 230, 232.
230. Yeah, 230, 232. 230, 232, and let me see the truth.
and what size, what did you say the frontage of the 230 and 232 were?
232, 9.9.
So they're still larger than what you're proposing.
Let me open.
You're
it for
proposing
you.
9.725.
Yeah, there are many of them less than that.
Okay, I'm waiting for an example that's in the block.
Example, okay. Mm, I don't. So 210 is 9.14. 210 is 1.94 meters. 20 Horsham Avenue. 9.14. And
All right, thank you.
9.8. 9.8 is 210. 338. 9.8. 338 is 9.8.
Okay, thank you. I'm going to ask, do we have any more questions right now? Yes, Ms. Martin.
Yeah, I didn't quite get it. Did you answer the question on how wide your driveway and your garage is? Is it for 2 cars or 1
Uh,
car?
It's 5.37
So it's
right
for
now.
2 cars,
So if we step back,
2 cars.
yeah, we want to park 2 cars. Yeah.
Have you
So if we
looked at
can-
designing for a 1-car garage to save the tree?
No, this is not for the tree. This is for the side yard setback. The tree is it's only 6.5 meters to the side lot line, and the tree is quite big. It's 0.6. Let me see. It's
No,
quite
but
big.
we're
It cannot be
asking
saved
about
anyway.
the fact that you've got a wide driveway
so.
to accommodate 2 cars side by side. Have you examined or looked at narrowing the driveway for 1 car? And would that assist to save the Little Leaf linden in the front yard?
The 0.6 diameter tree up to setback maybe 4 meters. So we only have 6.5 meters. Then we only have 2.5 meters.
Right, okay. It would
So
still give you more green space in the front. Thank you.
Any
yeah,
other
we
questions?
can cooperate with the urban forestry to narrow our front driveway as a requirement, right? To have some more green areas. So, but it cannot save, I think. Maybe.
Do we have any other questions? No? Okay, let's take this matter into committee for a brief discussion followed by a decision. Anybody want to get us started off? Yes, Mr. Nipfel.
Thank you, Mr. Chairman. Very briefly, I'm not convinced on the consent. The examples that were given are quite distant from this particular property, and some of them are larger frontages. So personally, I have difficulties with the consent, and I would not be supporting it. In terms of the tree and Ms. Martin's comments, it seems to me that, I should say that the site plans are extremely difficult to read because they're overlays. Both of the driveways are double-car garage driveways.
Yeah.
Which are taking a substantial amount of green space out of the front yard and the boulevard. And it would be helpful to see if, as Ms. Martin had suggested, if at least one of the properties had a single-car driveway, whether in fact the tree could be saved. So I'm not convinced by either by the consent or the variance. So at this point, I would not support the application.
Mr. Bartolo?
Yes, and following up on those comments, I'm struggling with this one a little bit because I do agree with a lot of the comments of my colleague there. And I read the staff report and I consult the map and I see the other stuff that's happened in the area. And 4 houses over, they had one that's approximately 10 meters that was severed.
Right.
And then another 4 houses beyond that, it happened again. So is it a neighborhood in transition? Are things changing? Yes. Is the overwhelming character larger lots? Yes. So I find that part a little bit difficult. I suppose in terms of the consent, I would go with the staff report, considering they've looked at the 99 lots as noted, and they said it's in keeping with the transition. But further to the comments on some of the other stuff about the green space and the tree coverage, there are certainly ways to design that out that haven't really been taken a look at. So I think I could support the consent. I'm leaning towards supporting the application as a whole, although it's kind of just on the edge of what I think is kind of appropriate, to be honest, if not a little bit beyond, but I can get past it personally.
I share similar concerns with Mr. Bartolo. I think I think the lot is eligible for consent, but that tree really gets me. And I think a 2-car driveway, right now it's a single property. You're severing it and you're putting 2-car driveways. That's equivalent to an applicant coming here and applying for a single-family home on the property with a 4-car width driveway. I just think it's a little too much, especially since you're pushing a little bit with the severances, a little bit under what some of the other ones have been. But yeah, the tree hangs me up. In terms of the variances, the side main wall height, I was right agreement with the community planning. There's about 1.5 meters of height here that just doesn't need to exist. It's not doing anything. It's either a 4-foot roof, set of roof trusses on a flat roof, or, you've got, ceiling heights that I think are just pushing a little bit too much. So I'm some issue there, but I agree with my colleagues. So I don't, if there's any other comments, we can hear them, but it looks like we might have ready for a motion on this.
I think my only other comment is kind of a general one, is that this is an application to essentially turn a single-family home into two duplexes, so effectively 4 units. And in doing so, in trying to create denser neighborhoods, I'm willing to push the boundaries a little bit because we still have to have the services, parking, and whatever for those to function. So if we're going to allow those uses on the land, I think there has to be some flexibility in terms of just making them actually usable and functional, and not having 1,000 cars parked on the street and having people look at alternate solutions. So I guess from my point of view, I give a little bit of flexibility when it comes to that.
Mr. Chair, can I just suggest, because there is some interesting views about this, when you do call a motion, do you want to just start with a motion for the consent? Because if it fails, the minor variances cannot move forward.
Okay. Well, we have a motion on the consent portion, if you want to deal with that separately. Mr. Bartolo?
Yeah, thank you, Mr. Chair, through you. in considering the application and what's recently happened in the neighborhood, I'm going to lean in favor of the staff report and put forward a motion to approve the consent. I'll make it subject to the conditions noted. Bear with me for 1 second. I believe it's conditions 1 through 7 noted in the staff report, correction in the staff email, the standard conditions of consent.
There is a forestry one if you approve the consent.
Yes, and subject to the conditions noted in the urban forestry memo attached. Thank you.
Okay, do I have a seconder for that motion? Okay, second by Ms. Martin. All in favor? Okay, opposed? Okay, Mr. Nitfeld and Mr. Allison opposed. So the motion carries. The consent is approved. Now let's deal with the variance portion of it. So I'm looking at the three individuals that just brought forward the motion on the on the consent. So if we've approved the consent, we're dealing with the variances now.
Mr. Chairman, would it be appropriate to bring forward a motion of deferral on the variances? Because as the discussion was being engaged in, it sounds as though there are alternate solutions that might be worth exploring. And so rather than turning it down or approving it, I could see the benefit of the applicant working further with the city on possibly revising these applications.
We wouldn't be able to approve the consent without some of the variances. Some of the variances specifically related are required for the consent. So we would have to make a decision on at least those variances that are pertaining to the consent approval.
That's correct, Mr. Chair. In particular, the lot area and the lot frontage,
Yeah, so variance number
which is
3.
required for the consent alone to move forward. So you cannot theoretically approve the consent and not at least approve those variances.
But you could defer the others and approve those variances. Is that correct?
If you approve them, you can't defer them.
Okay.
You can't do half.
Okay, I'm just trying to find a solution. Thanks.
If we can take this into committee and just discuss it briefly, I think we can come to a reasonable conclusion on it. From my point of view, it's variances 8 and 9 are the sticking points right now. If my colleagues would agree with that.
And even 10 perhaps, is dealing with the side main wall height, but you're correct, 8 and 9 are the.
And I would suspect that if you refuse 9, for example, it's going to have a carry-on effect on some of the other ones as well, right?
Yeah. I mean, you look at the top plate of the second floor, there's over 4 feet of flat roof there, you know, plus the accommodation of 11 and 9, and, you know, it's a lot. In terms of the height, I'd be willing to approve a modified variance on the height. Otherwise, I just wouldn't be able to support it.
Through you, Mr. Chair, just if you are modifying, just please be specific because there are 2 minor variance files. Okay, so because it's quite complex, why don't we specifically deal with each minor variance file as we move along in your motion.
Okay. 2 sets.
Through you, Mr. Chair, because the planning report was late, we should put it out.
Well, if, you know, if there is some hesitation with respect to the variances portion, we could deal with the variances related specifically to the consent, and then I presume they'd be back to the drawing board should they wish any other variances, or should they wish to put forth another application for that property that has been approved for consent. Just, yeah. Does that make sense? Correct.
Just also a quick reminder, if you proceeded in that fashion to come back, just keep in mind they will have to pay new fees. This is not a deferral if you move forward.
Yeah. Three and four. Okay, just to get things moving a little bit, just specifically, I think I made a note about those side main wall heights. I would be willing to approve at 8.5 meters. I'd be willing to bring a motion for that particular variance. That still gives him quite a bit of flexibility, and I think it helps to mitigate the scale and massing from the street side. So I'll put that out there.
Yeah, thank you, Mr. Chair. I can support that and bring a motion as long. I've already brought a motion to approve the consent. I'd like to finish it off and carry it through. There's merits to the application, although I think some modification is necessary, and if this is a modification that's going to get it done, then so be it. So if there's no more conversation, I can bring forward a motion.
Yes.
All right, thank you, Mr. Chair, through you. I'll bring forward a motion to approve this application subject to variance number 9 being revised down to 8.5 meters for both properties, and subject to the urban forestry memo that was, I suppose, applied to the variance, the consent anyway. And yes, and then we can add the two conclusion items in the urban transportation memo A and B, dated January 16th, 2025.
And are we the landscape, the front yard landscape?
What about variance 8? I think we should deny it.
It's facilitating that four drive lane.
Well, if this motion is not going to get supported, I'll amend it again to deny variance number 8 as well. So I can clean that up if staff didn't catch all those amendments.
I think we're okay. So this is a motion for both minor variances, and that you are varying variance 9 for both to 8.5, and you're denying variance 8 related to landscaped area for both minor variance applications.
That's correct.
Thank you.
Okay, we've got a motion on the floor. Do I have a seconder?
And there's forestry?
Yeah, we've made it subject to conditions of the forestry and the transportation comments as well.
Okay, we've got a motion. Ms. Martin will second that motion. All in favor? Okay, that's unanimous. The application is approved as modified. It was a bit complicated, but I'm glad we were able to facilitate some approval. Okay, so item number 2, 211 to 215 Rainey Avenue. This is another consent application to sever the lands into 4 commercial components. The variances that are before us are related to the proposed consent and easements that are associated. On file, I've got material from the applicant, community planning comments, a report from Transportation Services, Engineering and Construction Services, comments from Heritage Planning, and comments from TRCA. Do we have our agent with us? Mr. Larson?
Yes, Benjamin Larson, address 15 Gervais Drive, Toronto.
Okay, very good. We don't have any other speakers on this item. I'm going to ask my colleagues whether or not they require a presentation. I'm seeing not. Okay, we don't require a presentation. If it's all right with you, we're able to move into committee for a decision for you.
Certainly, thank you.
Okay, let's take this into committee. Just note on this, we see some conditions from community planning, transportation services, as well as engineering and construction services. I should also say I'm glad to see this sort of application come forward. It's nice to see where larger developments are being made. It's nice to see consents like this that divide up the retail space at ground. I think the planning term that we often hear is fine-grained retail. So it's nice to see this kind of coming full circle. Back to facilitate that. All right, Mr. Nipfel, we got a motion.
Thank you, Mr. Chairman. I agree. This is a welcome application. I think it's very straightforward and reasonable. I'd like to move approval subject to, there are, I believe, 7 planning conditions, 2 transportation conditions, and 2 engineering conditions. Subject to those conditions, I'd like to move approval.
Okay, and do I have a seconder? Second by Ms. Martin. All in favor? That is unanimous. Okay, application is approved.
Thank you.
Item number 3, 17 Kirkton Road. This is an application to legalize and maintain a rear yard concrete sports court. We've got 1 variance for rear yard landscaping, on file material from the applicant, and 1 letter of objection from 15 Kirkton Road. We have our agent or applicant with us. Mr. Valencia?
Can anyone hear me?
Yes, we can hear you. Welcome. Your name and address for us.
Hi.
Hi.
Yeah, it's Enrique Valencia of Valencia Enterprises, Inc., located at 9040 Leslie Street in Richmond Hill.
Okay, very good. We're going to ask for a presentation, seeing that there's some opposition to this file.
Yep.
Let's get the clock up, and the floor is yours, sir.
Okay, thank you very much. So good morning, Chair and members of the committee. Again, my name is Enrique Valencia of Valencia Enterprises, Inc. I'm the agent for the property owner of 17 Kirkton Road. The purpose of our application is to approve the variance for a sport court. The variance is as follows: proposed soft landscaping of 35.96%, which I'll just refer to it as 36% instead of 50%, for a residential lot with a frontage greater than 6 meters. I just want to start for context, just give this application a little bit of context. There were a few parties involved in the situation before I got involved, which has led to the state that we are in today. We'd like to share that this project was not proposed with an ill intent. The owner and his family consulted with the previous contractor, architect, and building inspector, all of which suggested the go-ahead of building the court during the process of an open building permit for the home renovation. We have correspondence from the city approving the sports court, even having gone out and measured it themselves. Unfortunately, there was a complaint about it after the permit was closed, and it triggered the sports court to be reevaluated. The primary reason for the sports court is to provide a safe space where the owner and her children can use the space for various forms of physical activities. This process of having to remedy this sports court after the fact it's been costly and stressful on the owner overall. So far, we've spoken with community planning and 2 out of the 4 neighbors. I was not able to get in contact with the 2 neighbors that did object, but the other 2 that are adjacent to the property, one located at the rear and one located on the other side of 15 Kirkton, they were able to show, one signed a support letter while the other just preferred not to be involved. He has no problem with it, but just prefers not to be involved. Community planning did have their concerns at the beginning, and thankfully, because of the strike, we were able to address it with ample time. If the application was approved or was to be approved, it would be with the condition of an additional drainage layer all along the perimeter of the rear yard. So we are suggesting a French drain. If everyone is familiar with the French drain, it's a weeping tile located about 2 to 3 feet deep, gravel, and then a topsoil or mulch right above that. Before I speak about the neighbors' concerns, I'd like to state the request for variance is soft landscaping only. I believe their concerns will be addressed with the explanation of the proposal, and we're hoping that it can be considered minor in nature and meets the 4 tests. So the variance itself, again, is for the 35.96%, which represents a partial reduction and still maintains functionality and visually appealing green space that contributes to the infiltration and vegetation. Like I said before, the additional French drains have been included as per the recommendation of community planning in the design to enhance stormwater management and ensuring an additional guard to adverse any kind of impact on the neighboring properties. The sports court provides a multi-use recreational space that adds functionality and livability to the property. Contrary to the neighboring claims that the court is exclusively for pickleball, it is designed to accommodate a variety of activities. The family and even her small children, they're not professional pickleball players where they're going to be practicing 4 hours a day. I'm sure throughout a summer, you can probably count on one hand how many times they may actually play that actual sport. But one game of pickleball is no different than children playing in the backyard. A game of tag or any other sports, hockey, basketball, soccer, anything like that. The intent of the bylaws is to ensure properties manage drainage, maintain greenery, and align with the neighbor's character, which a lot in this neighborhood particularly, a sports court is not uncommon. Many, if you look at the Google aerial view, even from a few years back, there's been sports courts all around the property, all around the neighborhood. My apologies. So the official plan emphasizes sustainability, functional outdoor spaces, and community harmony. I believe the variance aligns with these objectives by balancing recreational use and effective water management and aesthetic design. I think I'm running out of time here, but I do have 4 points I just want to point out about the neighbors. While the neighbors have raised concerns about insufficient landscaping and water runoff, I want to clarify that the soft landscaping calculation was professionally measured and meets the criteria outlined in the bylaws. For the owner to proactively address drainage concerns, again, the French drains are being incorporated. I believe the neighbors shared an image of
Final
their
words?
rear yard.
Yep.
I believe the neighbors shared an image of their rear yard being flooded. If you look at the date of that image, it's July 16th. That was the flash storm that impacted all of Toronto. So I don't think it's fair to use assumption for a yearly basis, but I'll just wrap this up. We do appreciate the concerns raised by the neighbors, and if you give me a little bit more time, I can address the other three.
We
But
made through
we
with
hope
the
that
Q and A,
committee
but
can see that this is.
yeah, we're
Okay,
at our
okay.
5.
But I do appreciate, yeah, no worries.
Okay, we'll come back to
So,
you for a
respectfully
response, and we may have
request.
some questions for you. Okay, we have another
No
speaker
problem.
as well on this item. In person, welcome. Please come down to the podium. And state your name and address for us.
Hi, my name is Susan Monticchio. I live at 92 Bideford Avenue, which is directly behind 17 Kirkton Road. I did make a written submission, which mainly addressed the nature of having a sports court, which basically encompasses the majority of the backyard in such close proximity to one's neighbors. I would like to add that this sport court seems somewhat out of character for this neighborhood, as it essentially takes up the entire backyard. I'm not opposed to someone building a sports court on their property. I am concerned that there be some kind of mitigation to offset the problems with drainage which may occur. I do believe the sports court to be some type of water-resistant surface, possibly concrete. I'm especially concerned now that this sports court has been converted into an ice rink. Where is all this ice going to go when it starts to thaw in the spring? I do believe there was no softscaping before the onset of winter, so it was just compacted dirt where the grass used to be. I'm concerned that the drainage could impact my property. I'm hoping my concerns will be addressed. Thank you for your time.
Okay. Any questions?
I have a quick question.
Ms. Martin, we have a question for you, if that's all right.
Oh, sorry, no, I have a question for the applicant.
For the applicant, okay.
Sorry.
So if there's no questions for the neighbor, let's take it back to the applicant. And just before we get to the questions, I do want to provide the agent an opportunity to respond to some of the concerns that were raised by the neighbor.
Hi, can you hear me?
We can hear you.
Oh, thank you. So yeah, just to address the neighbors' concerns. First off, right now it is in a state of limbo. I'll say, just because we weren't sure what the outcome of this committee was going to be. Obviously, community planning has been involved, and we did reach an agreement to ensure that the adjacent properties in particular would be protected from said water runoff. I have not been to the property in just, it's been the holidays. I haven't been there in a few months, so I wasn't aware about the ice rink, but it's still valid for what multi-use recreational use is going to be. I don't know how often the kids are playing there, and I'm assuming it's the kids that are playing either hockey or just skating at the back. And right now, there is no landscaping because there's no plan right now as to what to do. Once the committee is actually heard, then we will have to address it. Otherwise, the neighbors have every right to complain, saying that things are not being met and whatnot. But this is the main intention right now, to get this approved and then go forward with the additional drainage layers. That's why there's no new grass or anything like that, because of this potential French drain that we plan on putting in.
Okay.
Apart from that, I think she said about basically the overall size of it. Like I said, we're here to basically, that's the variance that we're here to fight. We're trying to state that the sports court is minor in nature of what they want to use, and like I said, even speaking to the owner and speaking to the other neighbors, Apparently kids go around the neighborhood to the houses that do have sports courts as well. And there's, I counted 5 just based off a Google image from 2020. So it's, I mean, not many neighborhoods have sports courts. If anything, this is the one that I've worked on that has the most.
Okay, thank you. Ms. Martin, did you have a question?
I have a quick question.
Of course.
Just in the public notice, it says that 50% of the rear yard must be soft landscaping. Yeah, the proposed rear yard landscaping area is 35. Does that include the deck, or is it just the soft, or does that 35% include the deck as well?
So it includes basically the back perimeter of the house. All that area is being taken into consideration. So as you can see, the house is like an L shape. So the deck is included within all that calculation.
That's what I thought. Okay. So it's not just the grass around the court. You've included the deck in your soft landscaping calculation.
Yes, because underneath the deck is, well, I don't include that specific deck into the calculation because even zoning wouldn't let me approve that.
That's what I
The-
just
the
asked
deck
you.
is covered,
So is
so
it
it's
included in
covered
the
in grass.
35%, or is it not included?
There's difference.
It's not included in the overall.
Is it
it's its
included in
own
the
separate
35%?
number.
Yes or no?
Sorry, I'm having a hard time understanding the question.
Sure,
So,
if I may
so
interject, Ms.
basically
Sure, absolutely.
Ms. Martin, just to help provide some clarification, there may, and again, I can't confirm this, but it seems to me, based on the public notice, there may have been the omission of the word soft. And it's important in this case because there's a difference between landscaping and soft landscaping, and I thank you for pointing that out. My understanding is that the notice is incorrect and that what they're actually, the 35.96% is just pertaining to the soft landscaping around the sports court and around the deck, but that isn't, for the record, I mean, it isn't confirmed. To me, it just appears like the omission of the word soft on the notice. We go back to the
We're
applicant
asking
Can
and,
the
I-
applicant, they should know, right?
yeah, of course.
They should know
Yeah.
what it
So I'm happy to
includes.
also clarify. So the landscaping percentages includes all the walkways. It includes the concrete pad, and then the rest of it. Within that landscaping, we have the 35% of the softscape as well. The deck is its own thing. It's not included in the landscaping calculation
Okay, thank you. That
because it's covered.
confirms. Thank you.
Yeah.
Okay, thank you for that clarification.
Thank you.
Any other questions? Okay, yes, Mr. Nitfeld.
Yes, thank you, Mr. Chairman. To the applicant, can you clarify the surface that is the sports court? It's poured concrete. It doesn't have any potential for percolation of water through it. Is that correct?
That's correct, sir.
In the event that it's used for hockey, are you putting barriers up to prevent flying pucks onto adjacent properties? And the reason I mention that is I have one of these 3 doors from me where I live, and we have flying pucks all over the backyards.
That it's hard for me to even assume what they're going to be playing. I know they have the ice rink right now, but I haven't spoken with the children or anything like that. And when this was brought up to me, it's a sports court. So how many days of the year they're going to be playing hockey outside, or if Jill is going to be skating in the backyard, I can't tell you an exact date. But you have to assume that even if they were playing another sport, you'd get balls on the other side. I know I have 2 nephews. They have soccer nets right up against the fences, and they're kicking the balls at the fence, sometimes even breaking them as well.
Okay, thank you.
Any
You're
other
welcome.
questions?
I have one more, sorry.
Yes, Ms. Martin.
I'll be quick. So you showed a picture of some concrete coming almost right up to a fence. Was that the sports court? Because if you look at your drawing here, you have a it says existing grassed area surrounding the whole thing, but this picture showed the concrete coming right up to the fence with maybe, 150 mil between the concrete and the fence. Was the sports court built like the way it looks here, or did you take a little bit of, and build it a little bit bigger towards a fence? Because it doesn't look like there's,
So you're only referring to the sports court, right? Because
just the
there is,
sports court. There was some sort of picture I saw where there was a concrete area almost directly up to a fence. So I don't know what that picture was.
that might have been the walkway, walkway that's shown right beside the deck. But all around the concrete pad, there is, right now it's just dirt.
Okay.
It's a soft
Okay,
landscape.
thank you.
Okay, do we have any other questions? Mr. Bartolo?
I just have one for the applicant. You had mentioned that the building inspector had come by and said that this was permissible under the open building permit. I don't.
Yes.
I haven't seen anything to that effect in any of the submissions here. Unless
I did not put it in. I did not upload that email correspondence. I'm happy to show it, and I prefer not to name the names of the inspectors or the people that actually came out to measure, which to me was rather odd, even when I first picked up the application. But then once I saw the emails from the owner, I was a bit shocked. But the thing is that we tried to get this, unfortunately, the permit was closed before we can apply with that, through that open permit and through that decision, because there was a variance for that, for the existing home. But it even got to the point that I needed a brand new survey plan, because I wasn't able to use the one that was used for the renovation, in order to pinpoint exactly what's on the property today.
Okay. I have a certain amount of sympathy when people act in good faith based on bad information, but I have no sympathy when people just lie. But I'm going to hopefully err on the side of caution and assume you're telling the truth on the specific items.
Mr. Chair, since there was a late staff report, would the members like us to quickly put it up?
Please, yes. In the meantime, I'm going to ask if there's any other questions. No? Okay, if that's the case, let's take this matter into committee for a very brief discussion and decision. Mr. Nipfel.
Thank you, Mr. Chairman. I agree with my colleague that when someone offers or operates in good faith, they have my sympathy, and I take the applicant at his word that he was misled, and he's now stuck with I would argue, an oversized court in the backyard, and the possibility of having to remove it is costly and surprising, given that he was encouraged to proceed with it. I have trouble with the size of the court, and I also have trouble with how it might be used. Because it's so big, it could encourage really active sports, which could create, as the objector indicated, a lot of noise, and not to make too small a point of it, but flying pucks can be dangerous. So I have concerns with this application. I have sympathy with the applicant for the fact that I believe he was misled, and I don't think it's reasonable at this point for him to have to rip all this up. I do think that the solution that he came up with was French drains, and he did it in consultation with the planning department, is a reasonable alternative for containing drainage, and on that basis, I'd be prepared to support the application.
I do support the idea of putting the French drains around to mitigate the problem with any stormwater management, to any runoff going onto the neighbors' properties. I'm concerned that I just want to make sure that that will be done in a timely process.
I don't think we can facilitate that action. That just have to be done unfortunately, out of good faith, out of the applicant, and, at the end of the day, your neighbors are still your neighbors, and you want to, put your, show good faith and show that you're trying to do your best to, mitigate your own
So true,
drainage.
so true.
So I will state that. Okay, we've heard some comments. Is there a motion that we can bring forward?
Mr. Chair, through you, the report's up if you
Yeah,
want to take a look.
just note.
Just a quick reminder.
Yeah.
Our staff report up with a recommendation in it. Mr. Nipville, please.
Thank you, Mr. Chairman. I'd like to move approval of the application, subject to the condition that's been suggested by the planning department for a revised site plan with drainage. As I indicated before, I think the court is too large for this property, and I have some concerns. But I do believe that in this case, with the French drains, the applicant has done his best to mitigate the concern. So I would like to move approval. I would, however, like, if we could, to put some notation that this does not necessarily indicate that we're supporting courts of this size on future applications. I have reservations about the size. I'm voting in favor because of the unique conditions here.
Okay, we've got, so that's your motion? All right, we have a seconder? Mr. Kaboo, all in favor? Okay, opposed? Mr. Allison? Okay, the motion carries. The application is approved with condition.
Thank you very much.
And thank you for coming down today as well. All right, item number 4. 111 Sutherland Drive. The purpose of the application is to construct a second-story addition and two-story rear addition to the existing dwelling in conjunction with other interior and exterior alterations. We've got some variances before us, including the number of stories, FSI, lot coverage, and platform area. On file, I have material from the applicant, letters of objection from the Leaside Residents Association, 115 and 119 Sutherland Drive. Do we have our agent or applicant online with us?
Hi, can you hear me? Hello?
Hello.
Hi, can you hear me?
Yes, we can hear you.
Hi, this is Parisa Amiri. I'm the architect and the agent on this application, and my address is 81 Cameron Avenue, North York.
Okay, thank you. We do have some other speakers to this item, so I'm going to ask for a presentation. No more than 5
Sure.
minutes. We'll get the clock up for you, and the floor is yours.
Yes, I want to start with the site plan. Yeah, as we see on the site plan, this is a 1.68 meter addition toward the back of the existing house. And we don't have any length, depth, side setback, and height variance. And the reason that we are asking for the number of the story is because the new bylaw reads the height differently, and this is the existing condition. If we go back to the page 810 section, it completely shows the existing situation and the addition. The addition is the existing main floor to be raised and adding the second floor. But by doing that, we are not creating any main wall height or total height variance. And the reason that the basement has been counted as the first floor is because of the new bylaw, like it reads differently. We are keeping the existing basement slab, and the midpoint of the basement is higher than the established grade. So technically, the bylaw reads this floor as the first floor, and the main floor would be the second floor, and the second floor would be the third floor. And this leads us to the fourth variance, which is number 4. For that reason, the deck, which is off the main floor from the from the family room, counts as the balcony. Usually balconies are on the second floor, but this is the deck on the main floor. But because of the existing situation of the house, which we are keeping the concrete slab, it counts as the balcony, and the balcony square meter is exceeding the deck. We don't have any problem with the deck. That's why I spoke with the examiner. That's why she wrote it like that for us. And in terms of the lot coverage and the FSI, the lot coverage and FSI doesn't create any other variances, such as the side setback and depth and length variance. And even if we look at, again, on the site plan, we are not going further back from the neighbors. And it's in the middle of the neighbors, both sides, and the addition is very small. We are adding just a little bit. And again, because it's because it's a major renovation, we are keeping the existing masonry walls all around. If we go back, if you go on page A2 and A3, which are the existing walls, it clearly shows that the interior area of the building is much less than has been calculated from the exterior. And the interior actually is not much. As I wrote in my design rationale letter that I've submitted to the committee of adjustment before, it's only 209, which is 69%. It's not the 76 or whatever that we are asking.
Okay. All right, thank you. Do we have any questions at this time?
Just a sec.
I have a clarifying question. You noted that
Yeah, but the depth of the lot is shorter. So in general, because of the existing situation, I think we are meeting the purpose, and it's very reasonable for us to ask and get the approval for these variances. If there is any question, I would be happy to answer.
all right, I do have a question for you.
Sure.
You notice that the first variance with respect to the number of stories is mainly on part of an existing condition. So is my understanding that the basement slab is existing?
Yes.
Is the ground floor also existing then?
No,
The height?
the ground floor is raised. The reason for this application is I'm not sure you have the existing photo of the house or not, or I can show you through the video. This house has the underground garage, and the underground garage and the main floor is on top of the underground garage. It's very convenient to use, and my client wanted to raise the underground and make it very normal garage to have the positive slope toward the street, not the negative slope, because it was very dangerous for them to use. So because of that, we were losing the garage space from the small main floor that they had. That's why we raised a little bit main floor by raising the garage. So we would be able to go on top of the garage for having the decent main floor. If you go back to the main floor plan.
Right, fair enough. Then to your
shows
submission, it's not really an existing condition then, because
basement is
if we're
existing.
talking about whether or not the basement slab is included, it's not just, that calculation is not just based on the basement slab. It's based on the proximity of the basement slab in relation to established grade. And you also have to take into account the first story, because if the first story is closer to established grade than the basement, then the basement therefore becomes excluded. But if you start manipulating the first floor, right, it's no longer an existing condition.
Well, before that, like they only counted the entrance, and again, it changed. They are counting the whole level and through the whole space. Like in the front, we don't have any problem because of the garage and the little bit of space beside the garage, which doesn't have that height, and it's under the porch and the foyer entrance. And the problem is only at the back of the rec room. And the rec room, we are keeping the basement slab because there's no point to do it with the underpinning.
I understand that, but
And also this,
Uh,
yeah.
I understand you're keeping the basement slab.
Lower,
Okay,
yeah.
all right.
And it could go lower because we don't have any problem with the total height.
All right. It was just a question. I just wanted the clarification on it. I think I've gotten that answer. I'll ask my colleagues if they have any other questions. No? Okay. At this time, I'd like to hear from our next speaker on this item.
Hello?
Hello.
Hello?
Hello, we can hear you.
Can you-
Your name and address?
Can you hear me?
Yes, we can.
I'm Shaheh Sabag. I live at 115 Sutherland, adjacent to 111.
All right.
There is no number 113 on the street. And from me, it goes north to 117. I'm a tenant under a lease agreement. I don't own the property. I've lived in Leaside the past 50 years and 20 of them in this immediate neighborhood. I've lived at this address for the past 5. I've submitted 2 letters of objections and concerns dated November 25 and January the 3rd. If there's a way of bringing up photographs from the November 25, it'll help us out.
Of course.
I just want to touch on the major points here of concern. I've got 4 items I want to address. 2 of them are objections, and 2 of them are concerns involving liability. Number 1, if you look at the photograph on page 2 of my November 23rd submission, I think you've got January up. There you go. Go scroll up, that's good. That's looking out toward, scroll up to the next picture up on page 2. That's looking outward to Sutherland in between the houses. Now, if you look at the left, you see the dining room windows in 111, and windows beneath it are the basement. Because it's an infill construction, it's going to raise the flooring of what is now the first story another 4 or 5 feet. And by putting another window on the second story, it's going to put a window between the houses that looks directly pretty much into my second floor bedroom, the master bathroom, and sideways into the master bedroom. These are the principal sources of light for us, as we have no windows on the other side of the house, nor windows that overlook into the street. I have a window in the master bedroom nonetheless. So I'm filing an objection to the placement of the window, and I'd like it to be gotten rid of. Number 2, the area between the 2 houses is going to be an area of considerable traffic, scaffolding, debris, et cetera, considering an entire new floor is being added to what is already a 1.5 story tall house. My attorneys and insurance carriers have expressed some liability concerns as to what might happen to damage to 115, damage to personal injury, to ourselves and visitors. This passageway is an active living space for us, and I've put some photographs in there to show you again in the November 23 letter on the final page. We use it regularly, and it's a major source of access to the back from the street, and also a safe passage out in the event of an emergency. When that is full of scaffolding and supports and whatnot that they are going to need for sure, considering they have to gut the entire property down to its carcass, we need some liability coverage provided by the applicant to cover any damage to property, to persons, to visitors, cars, whatever. That is on 115. Number 3, I'll just quickly run through this. 111 Sutherland is just an old house with a below-grade garage that's going to be infilled. Once it's filled, it's going to raise its ceiling by about 4 to 5 feet. The ceiling already, as it stands, is at shoulder height. So you're going to start with a house that's got a first story floor that's effectively 8 to 10 feet above grade. And on top of that, they're going to add 2 more stories to end up with what is a 3-story home that's really offensive. It feels a lot like shoehorning what is a monster home into a modest-sized Leaside community. Nobody in the immediate area is happy, even though not everyone has bothered to file objections. You have objections from me to building of a 3-story monster on Sutherland that changes the nature of the community and sets precedents for other future constructions, considering all other constructions in the area are all toward 2-story buildings with or without garages. And finally, there's a matter of a 3-foot encroachment at the front of 111 over top 115. I noticed none of the narrative from 111 addresses this. And I noticed that though one of their sketches includes the encroachment, the other one has conveniently omitted it. In the absence of any communication from the applicant or any engagement to get comments from anybody, they've lost our trust and faith, and they've lost credibility. And we will be putting them on notice that we're denying them access between the 2 houses. And we will also be filing other cautions on title and with the lenders as to any liability they might cause to us. Thank you.
All right. Any questions? Okay. All right. We have other speakers?
Mr. Chair, one question.
Yes, we do have one question for you, sir.
Yes, sir.
Go ahead.
Yeah, you indicated that you were never consulted. What would have you expected, or what would have made this application better for you and your neighbors?
I think simple dialogue is usually the civilized way to go with these things, to get a canvassing of what concerns neighbors might have. And had we been consulted, we would have voiced our objection to the 2nd floor window that presents considerable privacy impacts. And these are windows we can't close on our 2nd floor because we'd be living in the dark. So I found that particularly offensive. Typically, I've been on the other side of this. You consult your neighbors, you get the proper insurance in place to make sure that their property is not damaged. And if there's any danger of personal injury, that is covered. Unfortunately, the access to the front of the house at 115 Sutherland is across the driveway. We don't have a direct line of access to the front door. So the driveway becomes a very important source of traffic for us, for Canada Post, for deliverers, for visitors, and so on and so forth. There, you get the image right there. Basically, what you see in this little picture is the top of the garage. That's going to be the floor of the first level for this house. And they want to put 2 more stories on top of that to end up with a structure that towers over all the roof line of all the surrounding houses. And that's something we'd rather not have in Leaside. It's definitely not what you'd call Leaside vernacular.
Yes, Mr. Nipfel.
Thank you, Mr. Chairman. Could you clarify the photo that's on the screen right now? The yellow line is the property line, is that correct? And
That is correct, yeah.
Okay, and that the portion of the lawn and that retaining wall is in fact on the property, it's actually belongs to 115, correct?
That is correct, and that's supported by the survey.
Okay,
But
and
it's
therefore
omitted
the access to
from
the
the
rear
findings.
yard is completely on 115's property, is that correct?
Say again?
The access to the rear yard is completely on the property owned by 115, not on 111, is that correct?
That is correct, yeah. And the passageway between the two houses is a typical passageway where traditionally each house contributes about 18 inches to have a mutual 3 feet. But as it stands, 3 feet of the 4 feet passageway between the houses belongs to 115. And it ends up being used as a public access way from folks in 111, which is offensive.
Okay, thank you, that's been helpful, thank you.
You're welcome.
Yes, Ms. Martin.
Just showing the picture of the shed on 115. You don't have, are you right on the property line with that shed?
No, the shed, another 3 feet to the left of the shed belongs to 115.
So the
And in
property
fact,
line
if
is
you,
literally right on the, on 111's, it's right up to the wall of 111 then. Is that right?
about 18 inches, go to the photos below that. There are two images. There you go. This is the configuration on the little picture on the
Oh,
right. I'm looking toward the street.
but that doesn't show,
You see,
does it show the shed?
you see the corner of, the corner of the shed, it shows 115. That distance is about 3 feet from there to the shed.
Okay, thank
But
you.
next to the, okay, the line's about 18 inches. And you can see on the left photo, the property line that connects to the fencing.
Okay, very good. Any other questions? Okay, no, thank you very much to the speaker. I think we have another speaker.
I think we can hear you. If you can speak a little louder, please.
So my name is Reza Hamidanchi. I'm the owner of number 115 Sutherland Drive. My concerns are exactly the same concerns that were mentioned by Mr. Shah Sabak. Also, I have a main concern about the encroachment, about 3 feet in my property that needs to be corrected. As I've mentioned in the number one item in my proposal.
Sir, can we just get your address, please, for the record?
It's number 115 Sutherland Drive. It's the neighbor on the
Okay.
right side on the
Yes, very good. Okay.
just. And as you can see, my main concern is the encroachment of about 3 feet over the over my property boundaries, as you can see in the picture. And has been it's evident in the survey as well.
All right, any questions? Okay, thank you.
No questions. Thank you.
All right. Mr. Cattell with us today?
We've unmuted Jeff Cattell.
Hello?
Hello?
Hello? Yes, my name is Jeff Cattell. I'm with the Leaside Residents Association, 1601 Bayview Avenue. Our comments are perhaps a little more general than the previous deputants this morning, but we appreciate their concern. The LRA is in opposition to this application for several reasons. I would mention that, there were 4 items on the agenda today, and this is the only one that we're coming out for. because of the issues. There are only 4 variances: FSI, lot coverage, building height, and platform size. But as you understand, cumulatively, these are very important variances. They impact significantly on the actual size, the massing of the dwelling, and resulting in a major building on this street. These variances, in our opinion, are not minor. The height issue, well, the number of stories issue is a major issue. Leaside is a 2-story neighborhood. So as the previous speaker said, this is not part of the Leaside vernacular. And that's exacerbated by the flat roof. This building form does not fit the street and will be out of place. The floor space index, as you know, it's 0.6 times the area of the lot, and the applicant is asking for 0.7619. That's 27% over the allowable. This is a major variance. We don't see this kind of overage. It's just too big. It's too big for the lot. The lot coverage, again, there's a lot coverage variance, which is most unusual. And then the fourth one is the platform. There's a platform above the second story. The bylaw is permitted 4 meters. The proposal is for 11.15 meters. That's like 3 times above the allowable area. This will have privacy implications for the neighbors, and we would oppose that as well. So in closing, the impact of the proposed variances is too great. The size of the dwelling is too big for the lot. It's not in keeping with the character of the neighborhood, as expressed in the Leaside guidelines for preservation of Leaside character. And it's not in line with the intent of the existing zoning bylaws or the official plan, and does not, in our opinion, does not pass the tests under the Planning Act. We appreciate your consideration and request that the application be denied.
Thank you. Any questions? All right, no questions. All right, let's take this back to the applicant. I would like to provide them an opportunity to respond only to those comments that were raised by the 2 neighbors and our Residents Association rep.
Parissa, if you can hear me, I believe you have to authorize yourself to speak.
Oh, okay, can you hear me?
We can hear you now.
Okay, hi. I just want to start with the site plan because I want to have it bigger because I want to address a few comments that has been raised by the neighbors regarding the encroachment to their property. If you take a look on the survey and the boundary that I put on the drawing, it's clearly belong to this property and it doesn't belong to the neighbor, and we are not encroaching into the neighbor. This is the existing situation for the retaining wall at the front, and we are not. Ms. Martello asked for Ms. Nepal asked for the access to the backyard. We are not using this space to go to the backyard. There is a side entrance and at the other side on the west side of the property, and we are using that area on the other side of the property. There is a side yard, and it's a 90 centimeter access. We are using that one for the accessing to the backyard. We are not using their side to go to the backyard. And the existing side setback to the property line from our building to our property line is 47 centimeter, and at the back and 50 centimeter at the front. So that area is completely used by them, and the retaining wall is from the old wages that remained, and because of that tree, perhaps they put it in place, because clearly my client didn't change anything, and he bought it with this situation. This and that, and for the height, I think they got it wrong, because we are not filling up all the basement. We are just raising the garage to the grade level. So the basement is existing. We are not going on top of the basement with another 2-story. The basement remains. The main floor raises a little, and second floor would be added. So it doesn't go, and it's go very high, and it's not going to be very huge, because we are not having any total height or main wall height setback. It's only a number of the story, and the reason that I explained to you. We could add another expense to the project to make it to have the underpin and get rid of that variance for variance number 1 and number 2, but it's another expense, because with this situation, I didn't want to impose this expense to my client. And even, please, if you go to page 810, section AA, I put a line where it would be the basement. If I would go another 2 feet down, yes, I put the line under the basement slab. If I would go another 2 feet down and do the underpin, the basement would be a basement. I didn't have these 2 variances at all. But it's another expense to my client. I thought, well, we are going to the committee, and I can explain it to the panel to avoid extra expenses, especially in this situation of the economy. I didn't see it fair. And the other comment that they have for the window, if you go to the basement floor and the first floor, there were 4 existing windows already on their side, and even it showed on their presentation and their photo, there are existing windows to the existing house. I'm proposing to closing all those windows, and I'm adding only one small window for the second floor at the second floor bedroom. So the second floor bedroom, right, like whatever they have on their house, is the only means of natural lighting to the bedroom. So I'm not sure exactly where the lands, but they can. It can be a little bit adjusted in the bedroom to make them happy. Or these days, everyone have the blind. And in terms of the privacy, we are respecting their privacy more than before by closing all those existing 4 existing windows on their side. And in terms of the insurance, definitely when someone wants to go through the construction, they have to get the construction insurance in place. And these are civil matters that are not related to my job, but I'm sure my client was in contact with the owner at the neighboring property, and they were speaking a few days ago regarding the insurance and the caution that he needs to go through to build this house. I thought I answered all the questions and even the comments from the association, because those comments have been answered before. And the number of a story, as again I explained, it's the technical issue, and it would be gone by underpinning as well as the number 4. And 2.5% extra lot coverage is not extra at all. It's almost 8%.
Okay, final words? We're over our 5.
Yeah, final words. I think it's a very decent, decent house for the neighborhood, and even if you look at the main elevation, is not something out of character for the neighborhood.
Okay, thank you. All right, any questions?
I have a question.
Yes, Ms. Martin.
There seems to be a lot of talk about with the neighbors about the height, like how it's going to present itself on the street in relation to all the other houses on the street. Can you shed some light on what yours is at 8.5 meters, so you're actually not, you don't have a variance on the height of your building. What are some of the other, can you give any examples of other building heights on the street or in the surrounding area that might be comparable to your height, your proposed height?
Well, I don't have any height problem. Please, if you go to page A6.
No, I know you don't have a height variance,
Front
but
elevation.
there's,
Yeah.
the neighbors are
So the number
concerned
of
about.
stories on there, I think the neighbor, they are not expert to read the bylaw completely and comfortably, but this is the normal situation. And if I explain to you, if I had imposed another expense to my client to do the underpin, we would get rid of this variance altogether. And this is a very normal situation with the slope in the front, with the bay window, and there is no flat roof exposed on the elevation from the street. And these are all a slope everywhere. If you go to all the elevation, you'll see the slope around it. And the total height, main wall height, is complying, yeah, with the bylaw. And it's because of the technical issue. They thought everything is going to be on the grade, which is not the case.
Does that answer your question?
No.
Okay.
I just was curious.
It's
two houses down, beside 115, there looks to me to be a 2-story house. I'm just wondering
Yes,
if you know what the height of that, the entire height of that house is.
8.5 meters.
What?
It is to 8.5. Whatever the 2-story is in the lee side, and again down the street again toward the front again, everything is 7 meter for the eaves and 8.5 meter maximum toward the total height, which we already have it. Okay. And the cross street is the same. At the corner, the other side is a very new construction, is the same story. The eaves are 7.5 meter, total height is 8 and the eaves is 7 meter, total height is 8.5 meter.
Thank you.
Even the neighbor 115 is quite high.
Okay, Mr. Nitfeld?
Compared to the bungalow.
Thank you, Mr. Chairman. Variance number 4, you're asking for an increase in the size of the platform at the back of the house from 4 meters squared to 11.15 meters squared. The particularly least side, I believe, group indicated that that platform is substantially above grade and creates a privacy concern. Have you considered placing some kind of a visual barrier on either edge of that platform to offset privacy concerns?
Yes, definitely. And again, the reason that we have that variance at the first place is because of the first variance. It reads under the balcony, not under the deck. The depth of the deck is only 8 feet, and definitely we would consider to put the privacy of both sides to make it more private for my client and the neighbors.
Thank you.
Yes, Mr. Kaboo?
Yes, ma'am. So just wanted to confirm some of the issues from the neighbors were about consultation. And throughout your presentation, I was not very clear or how far you were able to consult with them and or whether yes, because they had about issues about liabilities, I think which for me are very relevant. And can you just let us know, let this panel know how, to what extent your client consulted with the neighbors and what they are willing to do to resolve some of the issues raised by those neighbors?
Yeah, sure. My client contacted the neighboring property, but this neighbor property, who is resident at that property, is the tenant, and he spoke with the tenant. The tenant asked for unreasonable compensation from my client, which was paying the rent of the length of the construction, because it's going to be inconvenient for him to live in that house. And my client contacted the landlord, and they spoke about this issue, and the landlord was concerned about the damages that may happen to the neighboring property during the construction. And my client confirmed that he's going to get the construction insurance, and he would be very cautious because it's not his first time to go through the construction to build the house. And he would be very cautious, and he knows how to protect the neighbors. In terms of the retaining wall, we didn't touch it because of the tree which is in the front, and we are dealing with the urban forestry to be able to work around it. And we got the approval to, because the tree is dead, we got the approval to remove it and replanting. I submitted all the documents to the committee of adjustment for the approval. And because of that, we would be able to touch the front landscaping, and we would rectify their issue that they have with the encroaching of the existing retaining wall toward their property. Definitely, it would be the next step, but it just happened after we submit the application to the zoning and the committee of adjustment. So in terms of the reassurance of their safety, my client will do whatever he can to make a safe transition from this existing house to his new house for the neighbors and himself. I
Does that
hope I
answer your question?
answered your question.
Okay, very good. Any other questions? No? Okay. Let's take this matter into committee for very brief discussion and a decision.
If I may, Mr. Chair.
Yes, Mr. Bartolo.
I generally agree with the applicant's comments. If they underpin the foundation, it would be considered a full basement. This would be a two-story building. That issue would go away. They're within the 8.5 meter height. There is no variance for height. In so doing, like, the platform is effectively at the first level. I don't think it's an overly large deck by any means. I think it's fairly typical size. And I don't have a problem with the FSI, so I'm prepared to support this application as is.
Sure. I'm not sure I agree with the application. I'm not sure I agree with the applicant's submission about just lowering the basement. I think we hear it sort of as a cop-out time and time again, saying, well, if I just lower the basement, therefore it's not considered the first story. But they still have access off the first story. They're still putting a garage on the first story. And if I think about purpose and intent about, this bylaw, about Leaside being a neighborhood of 2 stories, if we were to facilitate a third story, I'd be looking for things like angular planes, dormers, something that was embedded in the roof. And when I look at the front elevation, initially I get that, right? Like, I get the impression that they've been sensible to design, 2 dormers on the front with a roof and a slope. But then I go to the side elevation and I realize it's not really it's not really a slope. It's just a mansard roof with a dormer put on top. And if you compare it to other properties that the applicant brought up, I'll give 135 Sutherland Drive as an example because it's pretty close to the subject property. It is similar in nature in that there is a garage facilitated by, what looks to be 2 stories above, but that roof is a side gable roof. It's not a mansard roof. It doesn't facilitate an entire 3rd story. So I'm hesitant in this case because there really is a full 3rd story. I'm not quite sure. I'm not quite comfortable with the variance for the 3 stories. Those are my comments. Mr. Nipfel?
Thank you, Mr. Chair. And I agree with the chairman on this one. If you look at the front elevation, the way in which the building has been rendered actually makes it worse. The first 2 floors are substantially larger than anything on the street. The front door has a large pane above it. It's got a stairway leading to it. There's the garage, and then the the bay window that the applicant indicated, or the architect indicated the applicant was interested in retaining. I actually don't see that as a retained bay window at all. It looks like a very high building, and I don't think the way in which the front elevation is rendered, and to your point, Mr. Chairman, the side elevation is doing anything to make this building look or appear to be smaller. I have real problems with the risk variance.
Yeah. I think there's other parts of the city this might be appropriate, but Leaside is one. I would agree with the Mr. Catel's submission that Leaside is a neighborhood of predominantly 2-story buildings. It's not to say that there isn't an outlier here or there. Not to say I wouldn't be supportive of a 3rd story, but often cases these 3rd stories their 3rd story is integrated within a roof structure that has some adequate angular planes, slopes, and mitigation. In this case, it's just not sufficient enough to be considered a half story. It really is a full 3rd story. So, any other comments? Yes, Mr. Cabu?
Yes, Mr. Chair. I have appreciated hearing from the applicants regarding the process. Initially, that was my key concern, that they did not really consult with the neighbors, but from the explanations, they consulted with the neighbors. However, I still think that some of these variances are not minor, so I'm more than inclined not to move it to move on the side of approving this application.
Okay.
Yeah.
Was that a motion?
He put a motion to approve the application. Is any conditions with that, or just without condition?
Mr. Chair, I was saying I would not be comfortable putting a motion.
Oh, he's not comfortable. I apologize. Okay.
Is that a motion of refusal?
Okay. Does anybody have a motion they'd like to bring forward, see where it goes? Yes, Mr. Nitfel.
Thank you, Mr. Chairman. I move a motion to refuse the application. I believe that the opposition has identified a number of concerns. I frankly think height is the largest one, but I think that they've identified other concerns as well that clearly indicate that this proposal does not fit into the neighborhood and the community, and particularly into Leaside. And on that basis, I don't think it meets the tests of the Planning Act, and I would move that the application be refused.
Okay. Do I have a seconder? Second by Mr. Cabu. All in favor? Opposed? Mr. Bartolo is opposed. The motion carries. The application is refused. Okay, the time is now 12:27 p.m. Let's take a relief break. Let's say 5 because we are running a little bit behind. Is that sufficient for everybody, or? Yeah, okay. And we will resume as soon as everybody's back.
We didn't get any of the family that did they not?
The consent plans, they're right there.
Yeah.
It's not just, like, it's not just like, the items that, the ones that are not on the plan, you can tell me, we pay this off, we'll pay for it.
Yeah.
We're all in agreement too, like, this last thing too, right, it wasn't on the plan.
I'm getting my patience is wearing thin on the lower the base computer. I don't think you're circumventing purpose and intent, really.
I agree, and I also think,
Doesn't take the vision yet.
well, the other thing is, I went through a whole thing in Toronto about integral garages and how we put an integral garage in, and then everything else, everything's higher, everything's newer, everything's awful. Then leave the garage off. They're like, no, I actually said it on comments. I said, and why don't we just take the integral garage out? And he said, well, they're not what I want. I said, there's a number of options. And I just quickly, I gave him 3 options. And he said, actually, I've never thought of that before. He told me to his architect. I said, what do you think of that? And he was fine. And the proposal was great. It was fine.
It really messes things up.
Well, integral garages are.
I don't mind those third, like a third, but a sensible third. Not a,
I actually.
don't take me for a fool, but
Well,
I want
yeah, and if you look at Europe, you look at Holland, pitched roofs with dormers, they're lovely, and the top floor is not
45
obtrusive.
degrees
Yeah,
and
they're not
everything.
obtrusive, yeah.
And you still get big floor plates. But it's frustrating because you do get the garage and you think, well, they do know the basement, roof may be inside, but they still have an entrance off the back of the building.
Yeah,
And if the garage renders as the picture model,
yeah.
I mean, the purpose intent really on the 2 to 3 is really about the visual impact, then you gotta consider the visual.
Well, actually, we're designing the entire house around the garage, which is what the integral garage was supposed to overcome, you know?
The other thing with that house is that because they left
Hmm?
All right, we're back. Item number 5, 167 Lytton Boulevard. Purpose of the application is to alter the existing 2 1/2 story dwelling by constructing a rear second story addition and extending the 3rd story. We've got a number, 2 variances, building length and FSI. On file, I have material from the applicant, memo from Ravine and Natural Forestry Protection, letter of support from 155, 157, and 168 Lytton Boulevard. We have our agent with us.
Yes, my name is Joe Dome, 133 Torresdale Avenue, agent for the applicant.
Okay. Sir, I have reviewed the file. I'm going to ask my colleagues whether or not they require a presentation on this item. I'm seeing no. So if it's all right with you, we are ready to move into committee for a motion for you, unless there's anything else you'd like to add before.
That's all right. I would just like to add that the proposed FSI of 0.75, it's for a 22.11 square meter addition. So the existing FSI is 0.71, fairly minimal increase, and the design of the additions are sensitive and allow for maintaining the existing footprint as well as maintaining the existing roof line facing the streetscape, which will also have minimal impact. And there are a number of examples nearby, including next door, that have a FSI 157 Lytton. Next door to the east was approved for 0.787 FSI with a 21 meter length.
Okay, very good. Any questions? No. Okay, let's take this into committee for a decision. Mr. Nipville.
Were you going to go first?
Or Mr. Bartolo?
Go ahead. I think.
All right, Mr. Bartolo.
Thank you, Mr. Chair. I think this is a very straightforward application that's kind of sensitive to the existing condition of the neighborhood. I don't see any issues with it. Therefore, I'll put forward a motion to approve this application subject to the conditions of the urban forestry memo attached.
There actually don't have any,
No
sorry,
conditions.
yeah, there were no conditions. It's a Ravine memo.
My mistake. I thought.
Yeah, it's listed as a submitted memo, but the checkbox actually is no condition.
My mistake.
Thank you.
All right, do I have a second or seconded by Mr. Nipville? All in favor? That is unanimous. The motion carries. The application is approved without condition.
Thank you very much.
All right. Item number 6 we dealt with. All right, so we're on to item number 7, 7 MACNAUGHTON Road. The purpose of this application is to construct a 2-story rear addition as well as a 2nd-story addition above the existing rear porch. We've got 4 variances: side yard setback, a parking space, variance for a parking space in a front yard, lot coverage, and parking space width. On file, we have material from the applicant and a letter of support from 18 MACNAUGHTON Road. We have our agent with us.
Thank you, Mr. Chair. We have unmuted Jay Smith, but the speaker would need to authorize himself to speak.
Hello.
The application, my address is 2814 Hollington Crescent.
And can we just get your name again?
It's Jay Smith.
Okay, thank you. We just a little bit of cut off there. All right, Mr. Smith, I just want to confirm, I do see 2 other speakers on my list. I want to confirm they are with you, and you guys are the only party here today?
I am the only speaker I know of, Mr. Chair, in support of the application.
Okay, staff, can we just confirm? I see Ms. Hung and a Mr. Kofi. Just want to
They are
confirm.
the owners of the property.
Very good. Okay. Okay. I've reviewed the application. I don't require a full presentation, but I am going to ask my colleagues whether or not they have any questions or they require presentation. I'm seeing heads shaken. So unless there's anything you'd like to add, we are ready to move into committee for you.
Nothing to add. Thank you, Mr. Chair.
All right. Thank you. Okay. Let's take this into committee.
Go ahead.
Yes, Ms. Martin.
Yes, I think this project is respectful of the neighborhood character. It meets the 4 tests, and I would like to propose to approve this this application.
Okay. Second by Mr. Nipfel. All in favor? That is unanimous. The motion carries. The application is approved without condition.
Thank you, Mr. Chair.
Thank you. Item number 8, 137 Teddington Park Avenue. The purpose of the application is to legalize and maintain the as-built landscape features. We've got 4 variances required, including front porch encroachment, stair width, rear yard soft landscaping, and front yard landscaping. All right. On file, I've got material from the applicant, staff report from planning, a letter from our city councilor, and 11 letters of objection. Do we have the agent or applicant with us?
Yes, sir. Ali Shakeri, 326 Shepherd Avenue East. Good afternoon.
Good afternoon. All right, Mr. Shakeri. We've got the 5 minutes up. We do have some opposition to this, so I'm going to ask for a presentation from you. The floor is yours.
Indeed, if I can have my supporting material displayed. This is a very upscale neighborhood with many large houses, and there are 4 variances proposed. I think the main focus is on variance number 3 and 4 concerning the landscaping. The other 2 variances, because at the time I'm not going to speak about unless I'm asked question. There are some examples of the similar developments. For example, the other house now on the screen, number 177. This house has a very large. This driveway is larger than the one that we're proposing. We have actually. This is the existing situation. It's not permeable. The driveway we have is permeable. And this house has been before the committee of adjustment, and that there is similar landscaping variance for the front yard approved for this house. If we go to the next pages, there are examples of the other houses in the neighborhood. That's number 177 from the other angle. If we go to the next page, that is number 180. There is an extension of the driveway going to the back. So the entire number 137, the subject lot entirely will fit inside of that front yard. Number 175, same circular driveway with extension going to the back. You can just turn the pages, and I can explain quickly because of the short time that I have. Just go to the next page, please. Same house from the other angle. Part of the driveway is permeable. The other parts on the sides are not permeable. This is another house, number 174, with 3 entrances to the house. Very massive driveway. And the next page, please. Next page. Yeah, same house. Next page. Same house. Another entrance. There are so many entrances to this house. This is another house just opposite. Large driveway. As you can see, how wide is the entrance to the driveway? If we go to the next page, please. Another house. Next page. Yeah, next page. If you just hold on the next page, the area map, please. So yeah, this, as you can see, there are very, very large lots, and I showed like some examples of the driveways. What we're dealing here is a driveway and a rear yard landscape that is entirely permeable. I have submitted evidence after this that you can see, but One fact that I need to mention is that red highlighted lot is the subject lot 137. A number of years ago, the neighbor number 133 has purchased that blue parcel of the lot that is 10 foot wide from the owners that are my clients. And if we had that part, that would contribute to part of the landscaping. So we are a little, we are that the landscape is significantly larger than what it's supposed to be because we don't have that parcel of the lot. And then if we go to the other pages, please. Yeah, that blue highlighted is the, if we can zoom into it, that is the originally proposed driveway. This is designed by another architect, but unfortunately he wasn't available for this hearing, so I accepted to just to speak for my clients, which are my friends. The driveway that they have done and why they didn't basically go to the committee for it is in absence of Mr. Haji, the owner, which was dealing with very serious health conditions, his representatives were made sure that using the permeable, entirely permeable material is considered landscaping, which we know it isn't. But anyways, they did a very beautiful job with the, I mean, I'm going to show you on the other pages. If you turn pages, please. If you turn page. Could you please, yeah, those are the documents showing that everything done on the front and rear yard, they're all permeable. As a matter of fact, they have done very beautiful engineering with a French well system just as a backup, because under their permeable material, there is screening layers to adequately drain any surface water. There hasn't been any, they're living in this house for some 5 years, maybe more. There hasn't been any problem with the water, neither for them nor for any other neighbors. And that's thanking to the system. So now, when I look at the letter that councillor wrote or the planning staff, they're talking about like the lack of permeable surface or the surface water management, which is beautifully done for this lot. As a matter of fact, I went to the lot and I haven't seen anything done as good as this system, which the backyard is entirely flat, by the way.
Just final
So,
words,
if
Mr.
you-
Shakiri. We're well over the 5 minutes, so we're going to have to wrap. But I'm sure we're going to have another opportunity to ask questions.
Sure. So the main important thing is that the turning radius on that part of the Teddington is very, very, very limited because of the boulevard. And that's why they added to the driveway. And this, comparing to the other lots, is not big. You can refer to the photos that number 1 and page 1 and 2 that they submitted. And when I answer the comments, perhaps we're going to cover everything else that I want to say. Thank you.
Okay, thank you. Okay, we have some other speakers, but before we get to them, I should ask, do we have any questions of Mr. Shakiri? Yes, Mr. Bartolo.
Yes, thank you, Mr. Chair. Mr. Shakiri, the as-built condition which is causing these landscape variances, right? How does the as-built condition vary from what was approved? What did they build that is different than what they were permitted to build in the original COA approval?
Well, the front yard, the driveway on the approved permit drawings were significantly smaller than this. Having said that, it wasn't even functional. The width of the driveway, I didn't find any dimension on the permit drawings, to my surprise. But when I scale, it's something around like maybe 9 foot, less than 3 meters. The one that was originally proposed and was on the permit documents, that is not nearly enough for a healthy turning radius. That issue actually was brought up to the owner's representative at the time of construction by the transportation, where they were giving them the curb cut. And that actually led to having the entrances to the driveway and the driveway itself, because of practicality to be larger, so that's why they made it
Okay,
larger.
so,
But
I just want to make sure I've got the story straight. The driveway width was increased during construction to a larger size than was approved at the original COA application, correct?
yes,
Okay.
that's
And
correct.
what's the
Yes.
difference in
But
the
there was
backyard?
there was no variance. I must mention there was no variance for the landscaping in the front.
Fair enough. There was no variance, but the increase in size is beyond what was permitted because it took away the green space. Is that fair to say?
Absolutely correct, sir.
Okay. And same question in the rear yard. What is different or what it?
Yeah, usually we're permitted to have 50% of the rear yard as the hard landscaping, which we are exceeding here. The backyard was entirely flat. It was like a sump, causing drainage concerns. And with the system they created over there, with excessive surface, which is, by the way, entirely
I understand
permeable,
the
they
system.
could.
I'm familiar with the permeable pavers and permeable concrete. I understand the merits of it. I'm just saying, what did they build that is different than what was approved?
Well, initially there was no indication of any landscaping, so
Right.
the,
So
the
there
land,
was
the,
no
the
variance for
backyard.
landscaping originally, so they increased the size beyond, like, again, same issue as the driveway.
Yes, usually at the time of closing a building permit, they will look at it if the hard surface is more than 50%, then that triggers a concern,
Right,
which
and
they
then
did
somebody
for this
caught
lot.
this when when the permits were being closed or something along those lines.
Yes, that's correct, sir, yes.
Okay, because they went ahead and did the construction without getting the approval ahead of time.
That's correct,
Okay.
for the reason that I said.
That's enough for me for now. I think we'll hear from my colleagues or the others.
Okay. Any other questions at this time? Yes, Mr. Nitpill.
Thank you, Mr. Chairman. To pursue that just a little bit more, the decision was conditional, and you had to comply with drawing A01, which is a different site plan than what we have before us today. Is that correct? So there's a clear drawing here
that
is a condition of your approval.
That's correct, yes. But
so why did you proceed to build something that you didn't, that was completely contrary to the conditions of the previous variance?
Very fair question. First of all, being part of many of these hearings, usually it happens during the construction that the applicants or homeowners, they would go back to the committee of adjustment to seek further variances, even though the previous decision is subject to basically tied to a site plan or an elevation or something else. That's I've seen many of those. But why they didn't go for this before the fact was, as I mentioned, Mr. Haji unfortunately was absent, and his representatives were made sure by the contractor that using permeable material, which obviously they did, is not going to trigger any landscaping issue, and also not a surface water management.
Excuse
I
me,
believe they were right.
Permeable material has no effect on the bylaw. It's sometimes proposed as an alternate, but it isn't landscaping. So I think it's clear that you have a site plan here you were supposed to follow, or the applicant was supposed to follow, and you didn't follow it. I'm confused as to why that occurred. Deciding to build it in permeable pavers is an interesting idea, but it clearly is contrary to the conditions of your previous approval.
You're right. The permeable is, according to the bylaw, is not landscaping, hard landscaping. It is landscaping, it's not hard landscaping, and that is the area that they basically were misinformed by the representatives or the contractor. But anyways, that they went ahead and did it, and the proposed, the existing condition is very sound and has no surface water issue for anyone.
Sir, how do you know that?
Because there has been no filed complaint or no evidence that anything happened as a result of surface water. But I have to mention that the number 137, if you look at the first page of my supporting material, is higher than the slot. And we also get massive water, sorry, the second page. Maybe first or second page, the one that from the other angle. No, the first page, sorry. As you can see on the first page, yes. You see, just if you look at the side, the right side where I shown by an arrow, that house is higher, so significant water comes from that way. And that adds to the situation. And luckily, we do not have any surface water issue, not as a result of water coming from that side, neither running any water to any of the neighbors. If for this neighborhood, even a slight technical issue can become problematic, and you will see evidence. And I mean, the owners are unaware of any issue that is caused for the neighbors. And by the way, that right side is a parcel of the land that was sold to the neighbor, which is, I believe, is one of the objecting parties, and they sold it to the neighbor, which improved their lot a lot, especially with regards to non-compliance, legal non-compliance side yards.
Okay, thanks. Any other questions? Okay, let's get on to our next speaker. Just remember to state your name and address for us. We have anybody here to speak to? Let's, okay, let's, and your name, sir? Okay. Mr. Durnford, you're up. If you just give us your name and, again, and address into the mic for the record and for everybody listening online, and then I will give you 5 minutes to present to us.
Okay. So I was speaking with the technician who I'm representing 8 neighbors, and I have formal letters saying so that were submitted to the city. So I'm hoping for some leeway, 2 or 3 minutes in my remarks, as I want to make sure all their issues are addressed in my remarks. So I think you were asked in advance about that.
Absolutely, yeah. So let's just confirm this. So you are speaking on behalf. So correct me if I'm wrong, but you are here speaking on behalf of 139 Teddington Park, 150, 179, 170. Sorry. 150 Teddington Park, 179 Teddington Park, 176 Golfdale, 172 Golfdale, 168 Golfdale, 180 Teddington Park, and 179 Golfdale. Is that correct?
That's correct.
All right. Okay.
Okay.
So I will provide a little bit of leeway, and I appreciate the fact that residents, given that there is a lot of opposition, I do appreciate the fact that residents have, picked one person to speak on their behalf, and hopefully we can focus on the issues at hand.
Will I have an opportunity to respond to the applicant's comments at some
No.
point as well?
So you'll have an opportunity to speak. We may have questions, and then the applicant, since they are the applicant, they will get the last opportunity to speak.
I'll try to respond then in my remarks.
Fair enough. I will note that the applicant will only be able to respond to those issues that you raise or others have raised in opposition.
Okay, I very much appreciate it. So if you can hear me okay, I'm Andrew Durnford. I reside at 133 Teddington Park Avenue and immediately to the west of the subject property. I'd like to refer in my submission to my letter that was submitted to the city dated January 14th. It's a 32-page PDF, and I just want to look at some of the pages on that and give you some of the history. Your committee had questions of the applicant. So the first page is page 3 that I'd like to refer to of the PDF. So that's, yes, that page there. So when the development of this property was first proposed, Dr. Ting, who resides on the other side of whom I'm representing, approached Mr. Hadji about our concerns relating to issues such as drainage on the property and the proposed mass of his home. All three of our backyards have a drainage problem, as there may have been a historical stream in the area. Mr. Hadji's property, 137 Teddington, actually had a system to pump water out of the back garden into the front garden, and we're all level at the back of the property. We were open-minded about the development and negotiated an agreement with Mr. Hadji that in return for not objecting to his application at Committee of Adjustment, he would agree to develop his property subject to a few specific conditions which are directly relevant to this discussion today: soft landscape coverage. So if you, the property was to be developed in accordance with the site plan, including the driveway location and design, and you can see in that letter that specifically referenced the driveway location and design. So if we go to page 11 of the PDF, this is the agreed site plan, which you've seen. Page 11 of the PDF, it's site plan. Yes, I think that's it. Yeah. So I wish to draw your attention to the single-lane circular driveway out front and the entire back garden being soft landscaping. There wasn't a circular driveway there before. He really wanted a circular driveway. We agreed that if he put one in, it would be a single-lane circular driveway. He was extending his basement 5.6 meters into the back garden to accommodate an indoor pool and a 4-car underground garage, so he didn't need much above-ground parking, and we didn't suspect he would need another pool, as he already had one in his basement. So if we go to number 14, PDF page 14, which is the Committee of Adjustment notice, okay, it's basically the condition that was cited earlier in the notice of decision. He received 10 variances to build his massive home with the neighbor's support: lot coverage, setbacks, height, integral garage extending into the rear garden. But he did have a specific condition that he agreed to about building his property substantially in accordance with the submitted plans, including the site plan, which was page A01. So if we go to page 16, I think that's it, A01, you'll see a signature on the right. That's his lawyer, Jane Pepino, the representative at the hearing. And it was an absolute condition, and it's the same as the agreement that he had with his neighbors. And he was notified of this condition by his lawyer in an exchange of emails you'll see in my submission. So let's go to page 31, which is the as-built plan. And as you discussed earlier, comparing the as-built plan to the Committee of Approval approved plan shows the stark difference, and it's absolutely unprecedented for our neighborhood. So it's 31. Please. Keep on going. I don't know why these are, okay. That's the as-built plan. So you look at the width of the driveway out front, 7 meters across. I'm talking about across the frontage, not what goes down to the street, which they conveniently showed pictures of just at the street level. And look at the backyard. That's all hardscaping in the backyard. They put a pool in, if you go up a little bit, they put a huge, massive pool house in the back that required all the trees being removed on the rear lot line. So let's look at some pictures, page 32, which I think is probably the next one. That's Google Earth. So the property we're talking about is in the top middle there, compared to the neighbors. Look at all the hardscaping. Front and rear yard is practically all stone. And mine, I'm on the left, Dr. Ting is on the right, the Gulfdale neighbors are behind. Every single neighbor that surrounds this property has opposed this application. But just that visualizes what we're dealing with is the hardscape. Let's go to the page 27, front driveway. Keep on going, 27, 27. Okay, so that's the view from my front door. That's not a driveway, that's, well, it looks like Pearson at night because they light it up like a runway, but that's 7 meters wide, and on the next page, you can see when they park their cars on it, which are always massive SUVs and trucks, despite having an underground garage with 4 cars, it's basically the whole front garden is covered with hardscape. And this is not permeable. This is a heated driveway, and it's got a concrete base. There's no way water is going through that. And actually in the submission that they made to the city in October shows the concrete base of this driveway. Page 29 is, I think it's probably the next page. Yeah, that's the rear garden of the property. This is a photo from Mr. Hadji's website, company website. He's a real estate developer, showing the house and the garden from the very rear lot line. You can see it's all hardscape. If we go to the next picture, This is the rear garden looking back at the oversized pool house. Again, note the lack of soft landscaping. He cut down most of the mature trees on the rear lot line to build this pool house. And so he doesn't believe in trees or vegetation. So what are the implications of this built site plan? First, the drainage. The extensive stonework on the property causes drainage issues. He's talked about using this permeable stone. That's the first I heard about as part of this process. I agree with a committee member that said it hasn't been proven to be equivalent to soft landscaping. It just seems a fantasy to me and just does not make any sense. The hard landscape in the front yard is his driveway, which is heated, which is on a concrete base. It's not permeable. And I just had to install a French drain in my rear garden because of the water pooling issues that I'm sure are contributed to by the lack of water absorption on his property. Second, it's out of keeping with the neighborhood. He showed pictures of all the driveways in the neighborhood. These are all very old homes, and they had circular driveways, but none of the mass and size of his circular driveway. He stripped this lot, which was a beautiful lot, of all trees and bushes as part of his building, and the 7-meter wide driveway across the front of his house is just completely unprecedented. The final issue is noise. It's a really big problem with this property, and it's directly related to the soft landscaping. I know you don't deal with noise issues, but he's installed a nightclub quality sound system in this pool house and his house. It's a surround sound system, and at his frequent parties, he plays the music at extremely high volume, and the noise reflects off of all this stone landscaping, and it reverberates through the neighborhood. People are complaining from 2 streets away. Our house next door, it's vibrating. You can't even hear yourself think in the house. And he has a noise violation from the city that you can see in the record. In fact, I heard there's a court case relating to his noise violation in the system right now. So I don't believe this application meets the 4 tests. In summary, I believe Mr. Hadji, and this goes to some of your comments earlier, is a home developer with decades of experience. He knew what he was doing. He committed in writing to a site plan that did not require any variances on soft landscaping when he sought approval to build his home to you, the Committee of Adjustment. He was told he was building far too much hardscape by us, the neighbors, throughout the process, by a city inspector, Mr. Lemovsok, who we were talking to about it, and he chose to ignore it and continue to do the build. There have been huge negative impacts in the neighborhood, from the drainage to out of keeping with the neighborhood and the sound issues. So we ask that you turn down this application, particularly variances 3 and 4, which deal with the soft landscaping in the front and rear yard. As you heard, there's 11 neighbors, city councilor, and the staff report all opposing these variances. And we really hope that you reflect on that and reach a decision to refuse those variances. So thank you very much. I'm sorry if I'm a little over time.
Of course. Thank you. Any questions? Okay. All right. Thank you.
Okay. Thank you.
Okay. Staff, do we have any other speakers on this item? All right.
Mr. Chair, we have unmuted Boris. Boris might need to authorize himself to speak from his end.
Okay.
Hello, can you hear me?
Yes, we can hear you. Your name and address, please.
Okay, my name is Boris Kogut. I reside at 179 Teddington Park Avenue, and I'm a board member of the Teddington Park Residents Association. I'm speaking on behalf of the Neighborhood Association. Can I proceed?
Yes, sir, just also remind you, we've had quite a bit of testimony from one of your neighbors. Just please be mindful of just repeating any matters that have been raised.
Sure, thank you. First, I will speak to the integrity of some of the evidence that was presented initially. The applicant is a professional house builder and was involved in the building process very closely. He acted as his own general contractor. So when the applicant in the beginning of the hearing said that he was misinformed by his contractor, that's completely, that's dishonest, because the contractor was the applicant for the house. So he is a professional builder. Also, there was mention of the curb cuts being done to support the larger driveway. I'm a neighbor, and I saw that the curb cuts were done only after the driveway was built to the larger width. So the curb cuts only came after the driveway was built, not before. So it was, again, dishonest to say that. Also, it was dishonest to talk about the pavers, the drainage of the pavers, because the pavers we know might be permeable, but there was 3 to 4 inches, or actually pretty more, concrete underneath the pavers in the driveway because the driveway is heated. So it doesn't make any sense to kind of attribute any value to the permeable pavers. Okay, so I will speak next to the variances. So I'm here to object to 3 of the 4 variances that are being requested. First, we object to the front step variance. The front steps being 64% larger than maximum allowed. The excess size of the steps is inconsistent with the size of the steps in other houses in our neighborhood. The next variance we object to is the rear yard hard landscaping, being 67% in excess of maximum permitted. And the last variance we object to is the front yard landscaping, hard landscaping being 71% in excess of maximum permitted. These are not minor variances of 5 or 10%, and that is one of the reasons why we're objecting. These variances are not desirable. If granted, they will have a significant negative impact on our neighborhood and adjoining residents. These variances are not consistent with the existing pattern of neighborhood development. These variances are out of character with our neighborhood and would set a negative precedent if granted. I have personally seen storm water management issues created by excess hard landscaping at 137. With adjoining neighbors, that's Dr. Ting and Mr. Durnford, who was just speaking, having issues with their flooded backyards, also resulting in elevated risk of their basement flooding. Approval of excess hard landscaping in the neighborhood creates a precedent for future infill construction to do the same. Our neighborhood is known for having green spaces. One example is our boulevard planted with grass and trees. And therefore, I respectfully ask the committee to deny 3 of the 4 variances being requested. Next, I'd like to speak to the due process for variance approval. The applicant is an experienced professional house builder who is familiar with the regulations governing construction and knowingly built a house which required several variances to be approved, yet the application for these variances is being made long after completion of construction and occupancy. It's been about 3-4 years since the construction has been finished. The applicant disregarded the lawfully required process of applying for variances prior to the start of construction, disregarding the committee approval process, as well as disregarding an agreement he made with adjoining neighbors. Granting approval for variances requested several years after construction has been completed creates an unacceptable loophole for future development in our neighborhood. It would encourage other applicants to modify their plans at will and to disregard the correct procedure to obtain prior approval for variances. It is a backdoor approach to having variances approved after the fact, and it should not be allowed, particularly in this case where the applicant is both an owner and a highly experienced home builder who was present very frequently at the site because he acted as his own general contractor. Okay. Also, a comment on the
Final
application.
words.
There was one final words. The application for the 177 house that was put up as an example is not correct because that house was approved to keep the walls. When that application was approved, the applicant was going to keep the existing house walls, and therefore the neighborhood did not object to him having variances on the hard landscaping because that was grandfathered. Though that landscaping was there for 30, 40 years before. That's why we did not object. And that's why that application was approved.
Okay,
So
thank you.
Yeah.
All right. We got any other speakers? Actually, before that, do we have any questions for this speaker? No. Okay.
Mr. Chair, can I just, there's no other list of speakers, but can I just say a couple of words just really quickly? Now that I've heard some of the deputation and I fully respect their views, I just wanted to quickly remind perhaps the public and to say it out here, that committee is not a punitive body. So regardless of how we got to this situation, it's good for background. But in terms of looking for something to maybe vote against because they didn't apply for proper permits, that really should not factor or weigh much in your ultimate decision. You're only tasked with adjudicating what the variance is before you. There is a staff report. And if you've seen what we put up earlier, we put up the councilor's letter as a courtesy because there was a delay in posting it publicly. But I know it was in your agenda package. So we did put the councilor's letter up for you to see her position as well. Thank you.
Thank you, Mr. Treasurer. All right. Let's take this back to the applicant. I want to provide him an opportunity to respond to only those concerns that have been raised so far by the neighbors. We've got our clock up. Mr. Shakiri, are you with us?
Sorry, I just unmuted myself. My apology.
No problem. Floor is
if I
yours
can
for
have
response.
The first page of my support material, please. Mr. Darn from the issue mentioned the historical drainage problem of the area, and which we agree. And because of that drainage issue, they had that, especially for the backyard, they had created that system, which is working beautifully for several years. He mentioned this is a massive house. I disagree. I think this is, with regards to the size, this is a very modest house for the neighborhood. I have been working on other houses in the neighborhood, and they have been, even on this section of the Teddington Park, and they have greater FSI, including that number 177, which we have the precedent as part of my documents. If we go back to that first page, I need to mention a few things. With regards to 177, they have a greater FSI, and their driveway significantly larger than this, authorized by Committee of Adjustment, is not permeable. First page, please, if you don't mind. I thank Mr. Lamb for mentioning some of the things I wanted to mention with regards to this being before or after the fact. But if you look at this page, and if you can zoom in, this part of the Teddington Park Avenue, there's a boulevard. And if you see any lack of soft landscaping, I don't see. I think that the landscaping is very rich. In addition to that, my client, as mentioned, a developer, experienced developer, has added to the shrubs and trees significantly. In addition to that, there is the center of the boulevard on this area, and that side of the boulevard, because of the boulevard, there is very narrow pathway, so it's very difficult for cars to park and another car to pass. And if you see cars parking on that driveway, first of all, I think that's completely acceptable, but even in this condition, the neighbors should prefer those cars go on the driveway rather than just parking on the side of the boulevard, because it's like maybe 4 meters, slightly more than 4 meters or whatever, but it's very difficult when a car is parking another car to pass. This is not causing excessively large driveway comparing to the other lots. Evidently, as I submitted the document for 177, and as I've shown the other photos, Mr. Darnford showed a cropped air photo that, by the way, it wasn't submitted as part of the support material originally. I think this is a recent submission after the 5 days period. I wish I could do that. I usually get denial for it, but anyways, if you can just on your screens, it's very easy. Just go to the Google Maps and look at the area, and you can see the massive driveways. Driveways that, and I hope staff can at least show that aerial photo of the area. Number 180, number 174, number 177, number 165, number 175. These are like massive houses, larger than this, with massive landscaping, significantly larger than this. At least one of them I've shown to you that is authorized by Section 45 minor variants. And they're part of the same part of the Teddington. And I don't believe, that driveway, I don't believe that is creating a misconcept or something that is different than the neighborhood. And it's done in a very modest way that, you know, if you look at, again, my photo, the first photo from the street, you don't even see that part of the driveway that Mr. Dunford was explaining as a runway or something. I don't recall clearly. And I'm not going to comment about the nightclub quality sound system. I spoke to my clients and they disagree with that. The front steps, by the way, well, let's say if we just add just a couple of raised planters or something on the front steps, in order to get to that variance, yeah, we can do that. But I think the design, not done by me, but I think is done well, because those stairs are proportionally well fitting with the design of the house. So now regarding the backyard, I cannot find any evidence that if there is anything like that is with regards to the variance is done, but there are examples of the existing homes with massive landscaping. What I'm thinking here is that, well,
Final words.
would I?
Yep.
Sure. Would I do that if it was my house? Perhaps no, but there is an existing backyard. It's not causing, and as Mr. Kogat mentioned, 3-4 years it's been there. It's not causing any problem. It's adequately taking care of the surface drainage, and getting rid of that is gonna be done through like very aggressive, like invasive construction methods. That is going to be very messy, and it's going to create a lot of hassle for everybody to just eliminate something that is working like a charm.
Okay, thank you. We got to end it there. All right. Do we have any questions for Mr. Shakiri? No. Okay.
I do have one.
Yes, Ms. Martin has one question. I as well. Maybe we have the same question. Maybe we don't. But
mine's regarding the permeable paving. Permeable paving is a very specific application to paving stones, including 4 or 5 layers of granular of different sizes. Also, the paving stones are placed farther apart to provide, space for water to flow down, and can be also permeable in themselves. Now, the neighbors have said that there's concrete underneath your paving stones. Can you comment on that, please?
Well, I have submitted documents, page number 16 of my support material. And onwards, there are several pages submitted by the contractor mentioning the material and assembly. And yes, there has been screening layers, and I was informed that it is permeable. That's why, I don't stop at that. I would ask for documents before I come before you, and they submitted that document. I highlighted the important area. I spoke to the contractor personally. As a matter of fact, earlier today, they confirmed that there is 18 inches of the gravel and sipping layers that is adequately draining. I think it is very, very exemplary with regards to the techniques and the quality of all these landscaping. If they want to go ahead and remove it, it would be a shame. As far as I can recommend, but it's with you to decide.
Mr. Chair, there is a picture in the...
I can't. Okay, thank you. Mr. Shakiri, you gave a number of addresses with similar driveways. You said that this is a similar on the street. Do you have any quantitative stats to kind of support a reduction in soft landscaping on any of these properties? Because to your submission, I mean, some of these properties that you're putting out as a comparison are substantially larger properties. So if you add a circular driveway onto that property, the ratio of soft landscaping, right? Because that's really what we are here about today. It's not an issue about whether or not a circular driveway is permitted, or even if the width of that driveway is permitted. We're looking at the ratio of soft landscaping in the front and backyard with respect to those two variances. So are there any of those examples that you have provided, do you have those soft and hardscaping ratios available with those approvals that you noted?
Well, yes, at least number 177, there is the evidence of approval from the Committee of Adjustment. They not only got approved for the front yard landscaping, they also got approved for reduced soft landscaping ratio. We're seeking only one for this case, not both of the variances. That's one. And if you look at the aerial photo, and well, I'm sure I can provide this analysis that you requested, but not in the spur of the moment right now. I mean, if you wish to know, perhaps we can defer this to another date, and I would give you all those analyses, not only for Teddington Park, for everywhere in the neighborhood. It's just looking at the Google photo, looking at number 177, 175 is just beside it. It's very, very easy comparison. When we go to the other side, number 180, yeah, that's number 180, and the house beside it, number 164, I guess, or 74. These are like larger lots. Is the area of the driveway larger than, and significantly larger than a proposal? But they benefit from a lot larger front yard too. So basically, even if somebody forces them, they're not going to build any more than that as a hard landscape or driveway. But the driveways are massive. It's very easy fact if you just look at the Google photos for the area.
Very good. Okay,
And,
Mr. Nipfel has a question. Yeah, no, my question's answered. I thank you for that. Mr. Nipfel?
Thank you, Mr. Chairman. Actually, Mr. Chairman, I was going to argue your question wasn't answered because 177, he said, oh, they got a variance for landscaping. What was it? How much?
31.4%. You just read it. 31.6%. And they also got another variance for 49.72% of soft landscaping, where 75% is required. So they reduced from 75% to 49.72. That's authorized by variance. And also the comparable one is the variance that we are seeking. They're asking for 31. They asked for 31.6%. And approved by the committee. That is very, very similar to what you're asking here.
Okay, thank you.
Okay, any other questions?
And that's my question.
Okay. All right, let's take this matter into committee for decision now. Yes, Mr. Nipfel.
Thank you, Mr. Chairman. I frankly don't feel that this application has any merit at all. The original decision by the Committee of Adjustment was very specific. It indicated that the decision was conditional upon complying with the site plan that was before the committee at the time. And that site plan was not followed. The driveway was increased substantially, and the amount of hard landscaping was increased to the detriment of soft landscaping. That is a case where the applicant is himself a builder, and so I don't think that this is a case where somebody just didn't understand the rules. The rules were actually pretty clear. I frankly am concerned with all of the objections that I've heard, because I think that there are hardships being foisted upon this community that don't need to be there by virtue of this rather substantial amount of hard landscaping in the front yard and in the rear yard. I am unable to support any of the variances, and my reasoning is that 3 and 4 specifically deal with percentage of landscaping, but 1 and 2 also introduce more hard landscaping into the front yard than would be the case if the stairs complied with the bylaw and if the porch complied with the bylaw. So I'm unable to support any aspect of this application, and I hope my colleagues share my views.
I think I think I was okay with the first two, the canopy and the stair width. With respect to the other two variances, I'm very much in agreement with you. And I know that we brought up some other properties, but certainly when you look at the cumulative impact, right? This wasn't just done in the front yard. This is done in the front and the backyard. So the cumulative effect of hardscaping over across the entire property, certainly in comparison to others on the street, I think is unprecedented. So I would agree with you in that respect. Whether or not, I don't know that the stair width and the canopy is actually contributing to the hardscape. It may be contributing to the hardscape, but they still may be able to be in compliance simply by adjusting the driveway or whatever have you. That's on them, but
Adjusting the driveway would correct.
but if we take away the soft yard landscaping aspect of it and landscaping aspect, I think the stair width and the canopy are supportable. I'm not a fan of the fact that it was done against, to your point, against a site plan that was approved at committee. I could see with the canopy, the 0.1, how that could be an honest mistake. I mean, there's obviously, Mr. Bartolo knows, in construction, sometimes we veer off our measurements, but I think the stair was maybe more of a personal choice. I don't think that less than a mistake, but I'm curious to see how my colleagues feel.
Yes, Mr. Chair, I tend to agree with you, to be honest. If it was just variances 1 or 2 before this committee, I think we would have already had this file closed and done with. They're relatively straightforward. The 10 centimeters on the steps is fine by me. The proposed width of the steps, I'm okay with, but I would agree with Mr. Nimfeld and yourself on variance 3 and 4 is just too egregiously large beyond what's permissible.
Yeah, I would agree. Ms. Martin?
I think I'm in agreement with you, Mr. Chairman. I think that the number 1 is, again, it's maybe just a bad measurement or something. Number 2, I mean, if you look at the grandiose of the house, maybe it warrants the wider steps. It's the fact that they didn't go for the variance, but
Yeah, to Mr. Shakiri's point, proportionally, I think it's supportable. It kind of looks like it fits within the context within the neighborhood.
Right.
It's pretty low to the ground as well, I might say. It's not a very high front door elevation, so the impact of that is mitigated by simply by the height.
But 3 and 4 I absolutely refuse because of a number of reasons, including the fact that there was no rear yard landscaping shown on the plan, and they just went ahead and did it.
Yeah.
Without going for the proper permits
Yeah.
or variances that they needed. And I don't know the status of the trees that were removed, but
Yeah.
that's a sad thing as well. And also the front yard tree, we're lucky it survived, and we'll see how it does, right?
Yeah.
Because it probably did not meet the tree protection zone when they put in the driveway.
Yeah, fair enough. Okay, do we have a motion then? Mr. Niville?
Thank you, Mr. Chairman. I think the comments on 1 and 2 are convincing. Thank you for that. I would, however, move that variance numbers 3 and 4 not be approved. Variances 1 and 2 could be approved. And that complies with planning, so I don't need to put in planning conditions.
Okay, I have a motion on the floor. Do I have a seconder? Second by Ms. Martin. All in favor? That is unanimous. The application is approved in part. Okay. I'm going to ask everyone, we've got 4 items left on the morning agenda. Is the preference to push through to lunch, or do we need a 5-minute relief break? No, push through? All right, we're going through. We're okay on this side. I didn't turn my head. All right. Okay, item number 9, 151 St. Clements Avenue. The purpose of the application is to alter the existing 3-story detached dwelling by constructing a basement addition underneath the existing rear deck. We've got 3 variances for FSI, building depth and building length, on file material from the applicant, staff report from planning, and 2 form letters of support. We have our applicant or agent with us.
Yes, Arlene Beaumont, Outfit and Associates. We are the agents for the owner of 151 St. Clements Avenue. My business address is 2140 Winston Park Drive, Suite 26 in Oakville, L6H5V as in Victor 5.
Thank you. Are you aware of the staff report from community planning? Have you had a chance to review that?
Yes, I have.
Okay, and is there any concern with the recommendations noted in the report, specifically to attach any potential approval of a depth and length variance to be built substantially in accordance with the west and east side elevation drawings?
No problem with that.
Okay. That said, I don't have any concerns with this. I'm going to ask my colleagues whether or not they have any questions or they require a presentation. I see heads shaking. Okay. So unless there's anything you'd like to add, we're prepared to move into committee for a decision for you.
I have nothing to add.
Okay. Very good. Let's take this into committee. Yes, Mr. Kaboo.
Thank you, Mr. Chair. While reviewing the documents submitted, seeing the application is straightforward, so my mic was too up. Yeah, while on reviewing the document, the application is quite straightforward, and then the proposal is quite form part of the general neighborhood, so it does not change anything substantial. And so I'll put forward a motion to approve the application subject to the conditions, so which was subject to the conditions on the staff memo, which includes that variances number 2 and 3 regarding the depth and length of the be developed substantially in accordance with the west and east side elevation drawing as submitted.
All right. Very good. Do I have a second by Mr. Netfeld? All in favor? Okay, unanimous. That motion carries. The application is approved with condition.
Thank you very much.
Thank you. All right, item number 10, 335 Briar Hill Avenue. The purpose of the application is a proposal to construct a new dwelling. We've got 6 variances before us today, including side main wall height, FSI, west side yard setback, front yard landscaping, and building length. On file, I have material from the applicant, a community planning report, and a letter of support from 354 Briar Hill Avenue. We've got our agent with us in person today? No. Okay. Online? Oh, we do. Welcome, sir.
Hi.
I'm from 333 Briar.
Good afternoon, Mr. Chair, members of the committee. My
Very
name
good.
is Sia Zanjani from 15 Allstate Parkway, Markham. I'm the architect and the agent for this application.
Okay, very good. We do have a neighbor here that would like to speak to the item, so I'm going to ask for a presentation on this.
Absolutely. So before I start my formal presentation, I would like to make 2 minor corrections to the zoning notice. This wouldn't change the nature of the variances. It's just a typing error that occurred. Was caught very kind of last minute. So the first one is related to variance number 1. So instead of saying south side exterior main wall, it should say east side exterior main wall, so you're changing the wall south to east.
Okay, I'm going to stop you there. If we're going to change variances, certainly one to that degree where we're going to change south to east, we would have to look at a deferral. It's only fair to the neighbors that the information, the correct information is circulated to the public in advance. So I'll ask, if we do need to change variances, unfortunately, that's just the way it's got to go.
I understand, but if I may add, we're still referring to the side exterior walls. So it's just the naming there was a typing error in terms of naming. So you're still referring to the same side as it said. You know, if you read the variance, it would say south side exterior main wall. We're not changing that, so I'm sure everyone would be clear that we're talking about the side.
I know, but you're asking us to change it.
Having said that,
if we were to give you an approval,
I understand.
Yeah, if we were to give you an
case,
yeah.
In that case, we would proceed as it is, and deal with that at a later time.
It's noted in the plan report as an error. Okay. Just be mindful. We cannot, we can approve. We have the ability to approve based on what's written on the public notice. We can't change that. So if you did get approval and went to apply for a building permit, and that information on the approval, right, if we approve a south side exterior main wall, if that's not consistent, then, I mean, it's not at my discretion, but it's going to be at the discretion of Toronto Building whether or not they accept that. I'll be honest, I certainly wouldn't. I think that's an error, and I think it just, frankly, it just needs to be, that type of error needs to be corrected. If I was looking at the site plan, the first thing I would do is look at the compass and go find the south side main wall. So I'll leave that with you. It's your right should you wish to proceed, but I'm trying to provide some helpful guidance here.
Mr. Chairman, would it be helpful?
Mr. Niffel.
I appreciate that.
As well for the applicant to read the planning report because it refers to the south elevation as well. They have a condition and it references.
Sure. So
yeah.
Absolutely understood. So it's just, again, it's if you look at the south, it would not be a side elevation. But let's proceed. I think this is I believe this is minor enough that could be justified at building permit stage.
Yeah, if I mean, it's the applicant's choice whether or not they want to move forward. Okay. So let's go back to the notice. So just so we understand, when the notice says the south side exterior main wall, which direction is that side main wall that you're referring to facing? East or west?
That would be east.
Okay, so it should say east. All right, and are there other errors you mentioned in the notice as well?
Very similar to number one. Number two also discusses the opposite side exterior wall, and the direction of that should change from north to west.
Okay.
And that's it.
Okay.
Here, come look at mine. Here it is. Here.
So, sir, it is your wish, it is your ability, it is your right to proceed. But I'll put a concern out there. If I was one of the immediate neighbors, you've got two sidewall variances, and each of the variances carries a different height with it, right? So,
correct.
this is also part of the issue, right? So if I'm the neighbor on the east side and I don't understand this correctly and it's been changed, how am I to understand that the side main wall isn't, for example, 7.75 instead of 9.59? Because again, it's not clarified on the public notice.
Mr. Chair, can I just quickly chime in? I share the concern about the public notice. My other concern is, if you read the staff report, if you approve this, it's recommending tying it to plans.
I think my concern's more to do with public notice, though.
That too. No, absolutely. That's the number one concern, is I don't think the notice is correct. And we do have a speaker, so I
Yeah.
am cognizant that the information that went out in the public notice may not be what is actually correct. The
Yeah.
second being, and maybe to the detriment of the applicant, there is a staff report recommending tying it to plans. So if there's some thought to shifting things around, it likely will pose challenges at the building permit stage. I'm just quickly mentioning that.
Thank you. That's very helpful. Okay, so let's go back to the applicant on this. I would like to hear from him whether or not he wishes to request a deferral or wishes to proceed, and we'll see what we can do to work through this.
It's honestly, it's hard to say, because again, this was something that initiated from zoning, and if you were to look at variance number 4, then number 4 is referring to this to the same side as one of the variants number 1 and 2, but then it's referring to it as a west side. So I to be honest with you, I don't know how to deal with this. My understanding that the bearings are fairly clear, and we're not changing the bearings from, let's say from a side elevation to a front or rear. We're looking at the sides, and on the drawings, they're distinctly clear as to which drawing and which side we're talking to. So
Okay. Fair enough.
I guess I would. Yeah.
Okay, well, you know what, before we get into a presentation, I would like to hear, we do have one individual here. I suspect they have some concern with the public notice. I would like to hear from them, and perhaps before we get into a presentation, into the merits of the application, we can just deal with this. So for that reason, I'm just going to stand you down before a presentation. We will come back to you, but I do want to hear from is it Vistorino? Did I pronounce it right?
Very good.
Okay, thank you.
Yep. Hit the button, or am I on? Can you hear me?
So I don't want to get into the merits. Normally we'd have you up, we'd discuss the merits of it, but I just want to speak to this matter on the public notice, whether or not there's a concern, whether or not you feel that there needs to be a recirculation or not.
I totally do.
Okay.
I've talked to Scott Morrison, who's my next door neighbor, and the Morrison name is, I'm sure you know, have heard of that, and he's been here before. And Scott was talking about the notification problems that we had throughout when the mail wasn't being delivered.
Yep.
So that caused a lot of issues to us, and we'd like to defer at this time so we can get our information properly.
Okay, fair enough. All right, let's leave it there.
Mr. Chair, I can also just quickly mention as well, you, as a committee panel member, any one of you can defer an item if you feel the public notice is not accurate. You don't need to rely on the applicant to do so.
Of course. I was just getting to that. I personally don't feel comfortable proceeding. If we did proceed, I frankly, I wouldn't be able to support those variances, frankly, just because they haven't had their proper circulation to the public. We had an individual that registered, came to speak, and expressed those concerns. So I'm going to make, actually, let's do this and see where it goes. Let's take us into committee. I'm going to make a motion to defer the application. I'm going to see what my colleagues think, and we can go from there. So I'll make a motion to defer the subject application to provide correction of the public notice as noted in variances number 1 and 2, and also perhaps to provide the applicant some opportunity to discuss with neighbors that may have some concerns. So, do I have a seconder by Mr. Nitfeld? All in favor? Okay, that is unanimous. So this application is deferred. All right, number 11, 328 Rumsey Road. Purpose of the application is to construct a new 2-story detached dwelling with an integral garage. We've got 8 variances, including building height, building length, FSI, north and west side yard setback, lot coverage, north side yard setback for a platform, west side yard setback for a front porch and canopy. On file, material from the applicant, staff report from community planning recommending some modifications, as well as a memo from urban forestry. We have our agent with us.
Afternoon. Hello.
Hello.
Hello, good afternoon.
Your name and address for us. Sir, your name and address?
Hi, good afternoon. My name is Hossein Mokhtari. I'm located at 14 Page Avenue, North York, and today I'm representing the owner of 328 Rumsey Road.
Okay. Sir, are you aware of the staff report? And it looks like you've been in discussion with them and have made some changes to this application, if I'm not mistaken?
Yes.
Okay.
Yes,
So
correct. I will go over the
Yes, let's bring up the
modified
public
variances
notice, and I'm going to have you take me through it and let me know what changes you'd like to make on the floor today, okay? Starting with variance number 1.
Yeah, variance number 1, the building height reduced from 9.76 meters to 9.40 meters.
Okay.
Variance number 2, building length reduced from 18.45 meters to 18 meters.
Okay.
Variance number 3, floor space index FSI reduced from 0.8 to 0.78.
Okay.
And the last variance number 5, the lot coverage reduced from 36.41% to 35.51%.
35.1%. Okay.
No, sorry, 35.51%.
Thank you for that clarification. Okay. And no other changes to variances 5, 6, 7, and 8 then?
The lot coverage was the variance number 5, actually.
Oh, I apologize. Yes. Okay. Just give us a moment here. Sir, if an approval were granted, would there be any concern to tie to site plan or any of the elevation drawings?
You're good with that. That's fine.
Okay.
Mr. Chair, I just want to caution, if he's made a substantial change in the entire application, so it may not be appropriate to tie it to the plans as is.
Thank you for pointing that out. Okay. I'm going to ask.
Actually, sorry, the latest drawing that has been submitted, it's the revised drawings according to the variances, the modified variances. If you can check the site plan, the length of the building must be 18.
Okay.
Yes, that's
very good.
So
you came prepared today. Okay, so can we, just to clarify, I do see the revised plans that have been submitted. I just want to confirm the date on the on these drawings, just to separate them out?
Sure.
Is it the
The
revised?
latest
Yep.
revised drawings is 22nd December 2024.
December, November?
22/11.
November.
Oh, sorry, November, correct.
Okay.
Yeah, 22/11/2024.
Okay. Ask my colleagues before we get into a full presentation, which we may not need. Do we need a full presentation on this? No. Okay. My colleagues are saying we don't need a full presentation. I should ask if we have any questions. We've got our modifications. No.
You'd mentioned, Mr. Chairman, you'd asked whether there was any problem tying into plans. Was there some specific plans that you wanted?
You can, they are on there. If you zoom in on the bottom, on the tab. Oh, I don't. We don't even need them. Yeah, but I mean, I don't think.
No, I just wondered if it was something specific you wanted to tie to.
No, I was just checking.
Yeah, okay, good enough.
Just trying to make sure we got our ducks in a row. Okay. I mean, given the design, I don't think it's necessary.
That's the other option too, that you can forego that
Yeah.
if you're happy with the text.
I think so. I just wanted to make sure that option was available should any of the members wish to exercise that. I don't. I personally don't see a need to attach to any drawings. So maybe I've just taken us down a path we didn't need to go. My colleagues are.
Mr. Chairman, I don't see a reason to. The only drawing that might actually in the future be an issue is the second one about how the car storage works. The fact that the cars come in at one level and they're lowered down, because that isn't immediately obvious from site plans, but I don't actually think it needs to be tied to the drawing.
Okay. All right. So just let's go back quickly to the applicant. It doesn't appear we need any more information, and we are ready to move into committee for a motion for you. Is there anything else you'd like to add at this time?
No, Mr. Chair, there is nothing to add.
Okay, thank you very much. All right, let's take this into committee now. Mr. Nitfeld.
Thank you, Mr. Chairman. With the changes that were recommended by the planning department, I think this is quite an appropriate application. I don't think it's in any way inconsistent with the neighborhood or the neighbors. It fits in rather nicely. I'd like to move approval subject the approval of the revised application with the changes proposed by planning, in addition to, I believe it's a forestry number 3 condition.
Yeah. All right, we have a seconder. Second by Ms. Martin, all in favor? Okay, that is unanimous. The application is approved. Okay, moving
you
right
very much.
along. Great. We're on the last item of the morning. Number 12. 163 Ledbury Street. The purpose of the application is to construct a pool and update some landscaping. We've got one variance for rear yard landscaping before us. Here. On file, we've got material from the applicant. We have our agent or applicant with us.
Good afternoon.
Good afternoon.
I promise I'll be the shortest one and also the last one on the list.
All right.
My name is Anthony Zahari. I'm representing my company Land Design Canada, located at 7250 Keel Street, Unit 345. We are the authorized agents for the homeowner of 163 LEDBURY, and I'm here today to present a request of the relief of the bylaw of the green and hardscape percentages. The request involves an adjustment to the softscape and hardscape ratio. We're seeking relief of 3.4%.
Okay, just give me a moment here. All right. I'm going to ask my colleagues whether or not they require a full presentation on this item.
No.
Nope. Okay. So to the applicant, it doesn't appear we need a presentation. So if it's all right with you, we will move right into committee for a decision for you.
Thank you, appreciate it.
Of course. All right, let's take this into committee. Yes, Ms. Bartolo.
Yes, thank you, Mr. Chair, through you. I think what's being requested is minor in percentage and in absolute terms. I don't see any adverse effects coming from this little bit of landscaping that's being requested. Therefore, I'll put forward a motion to approve this application.
All right. A seconder?
Go ahead.
Oh,
I just want to add in that there was a forestry advisory to provide 20 cubic meters of soil in an area to plant trees. I don't know if we want to consider that.
From our forestry matrix, I don't see forestry had provided any comments for this particular item.
Really? Where did I see that then? I didn't, it wasn't in there? Am I wrong?
No, forestry gave us
Forestry
the go-ahead because
January 9th.
Okay, so sorry about that. Why don't we pull it up? Why don't we pull this back a little bit? My apologies.
if there was a January 9th, why didn't we receive it?
read a late report in.
Sorry.
I don't see it.
You don't see it, it's there. It's under the forestry report. January 7th, it was, it is there. January 9th, it was posted. It's the third item down on the supporting
So it's an
docs.
advisory. You could add it as an advisory.
Yeah, we could add, I mean,
Sorry, Mr. Chair, we're just going to put it up for a second.
Thank you, that would be helpful.
it's to ensure that there's some substantial landscaping around the pool and not just sod.
If I could just comment, if we're not disrupting any perimeter drainage, I don't see a reason needed trees in certain areas.
Mr.
And
Chair,
the
we're just going to
substantial
pause
trees
this while we put the advisory memo up at this point, please.
I don't have it either.
I don't know. Anybody have any comments on that?
No, it isn't.
Okay, I'm going to take us out of committee just for a minute. I do want to ask the applicant if he has seen this memo from Urban Forestry.
No, I did not.
He hasn't. Okay, so
Did not.
I haven't seen it either. So let's just take a quick look. Staff, can we scroll down just a little bit? I see. Recommendation. just want to make sure, it just seems like we just want to provide adequate time because the agent hasn't seen this either.
I'm wondering why this was so late brought up to us.
Sorry, say again?
I would like to know why this was so late brought up to us and then also not sent to us.
I can't answer that question, but you can reach out to forestry and ask them. I might have the same question for them.
I have.
Yeah,
It's been
because-
posted, sorry, Mr. Chair, it's been posted on the public's AIC, so it has been visible for some time.
Ah,
Okay.
just wondering why it didn't show up in our.
Yeah, I never got it either. So.
Okay.
I'm not gonna lie. This application with some of the members from the city of Toronto has been more than difficult for such a super small application and variance. Like we're only asking for 3.4%, which is absolute minuscule and probably what you guys have ever seen. And the only reason why we did that is because we tried to get the approval of the committee. Now that we're getting this, it's like, where does anybody have to plant a shade tree in the city bylaws? You know what I'm trying to say? Like where do you never see something like that?
Right. Well, I will just kind of start by noting that it is a request from forestry.
Mr. Chairman, I wonder if there's another solution. Drawing S1, I'm giving it perhaps more credit than it deserves, but it shows a landscape barrier along 3 sides of the property. I was going to ask Mr. Bertoli if he would be open to including the site plan as a condition of approval. I can't figure out if the dotted gray is in some way in the legend indicated to be soft landscape. I think it is, because if you look on the legend on the side, there's soft landscape.
Yeah, all around.
So
all
I'm
around the
assuming that the
perimeter
drawing basically indicates that there is soft landscaping.
That's correct. Yeah, we're only 3.4% harder than required as far as a relief. So there is trees being planted on the, I could tell you right now, it's on the right side of the drawing.
Yeah.
Let's just say that.
So.
And also there is trees planted on the left.
I just have a quick question for you. So on your drawing here, it shows artificial turf. Is that a product that is going in? Because it doesn't show it in your, it shows it written, but not in your legend. I don't think.
It's okay. Well, it's okay. So that artificial turf is actually considered hard.
I can't hear you.
Or sorry, yes. You can't hear me now? Can anybody else
Maybe
hear
a
me?
little louder.
That grass is actually real grass.
Well, it says artificial
So
turf.
okay, well, anyways, the percentages are as shown. It's all calculated properly. Maybe there's a denote misunderstanding.
Maybe it's.
Okay. Any other questions? Yes. Mr. Nitbo?
Mr. Chairman, I go back to the same point. I think attaching the site plan in this case, if the applicant has no difficulty with that, is an easy solution, because as I read the legend, the gray area around the pool, the back and the 2 sides of the pool, is noted as gardens, so clearly soft landscaping. And I think that addresses at least part of the issue, and I think it would be prudent in this case to actually attach that drawing as a condition if the applicant has no concerns with that.
What is the issue?
What would that achieve, though? If
Shows that
the ratios are.
The issue was that there's no soft landscaping. Well, the drawing indicates there is.
Yeah.
No, the comment wasn't that. It was
I'm
that
sorry, I
they
misunderstood
wanted the applicant to provide enough soil, which is typically 20 cubic meters to support a larger shade tree in the backyard.
Yeah, but there's Okay.
Yeah.
Well,
That-
maybe save
It's
this.
also a request, not a requirement.
It is a request, it's an advisory, it's
Okay.
not a requirement.
So we're gonna get a little,
I
before we
mean-
get ahead of ourselves, let's take this into committee. It looks like we're getting towards a motion on this.
I think my motion stands. I'll approve this application as is.
Yeah, okay. I'll second Mr. Bartolo's motion. I'm satisfied with the fact that he's denoted gardens. I would presume that the sod and gardens are essentially the actual ground. I don't see why you couldn't plant a tree. I think there's enough setback and sufficient. I don't, yeah.
Really?
They still have to, though, provide that amount of soft landscaping back there. Okay, I mean, you could make it subject to a submission of a site plan if you felt that it wasn't being met, but it really should, I think that's over. Yeah. Okay, Mr. Bartolo, we have a motion on the floor for approval. I second that. All in favor? Okay, that's unanimous. The motion carries. The application is approved. Okay, guys, that
Thank you
concludes
very
our
much.
morning session. The time is now 2:15. We will resume our 2 p.m. session at 3:15 p.m. Okay, thank you.
I don't know. Wow. Anyways, just press that button.